Hello, everyone, and welcome to One Civil Law. I hope you're having a great day, and we are here to try to do a reaction to the oral arguments that were made before the United States Court of Appeals for the D.C. Circuit in the ongoing Michael Flynn saga. So, when we last left the action, Michael Flynn was convicted. Well, he pled guilty to be more precise. He pled guilty to one offense of lying to the FBI, which is a violation of 18 USC 1001, which is like the FBI's favorite law in the world because they use it all the time. Anyway, so he pled guilty to that, and then some information came out that he was essentially set up, and then the government wants to withdraw the issue. And the judge is not thrilled with that. The judge says, I don't want to dismiss this. So now this gets into an argument as to whether or not the judge has to dismiss it, because there's this Rule 48, that says that with leave of the court, the government can dismiss. So then it becomes an issue of, well, what exactly does that mean with leave of the court? What does the court, can it do? What are the limitations here? We want to give every word in the law effect, so we can't say it doesn't mean anything. Now we can give it very limited meaning, that's for sure. We could constrain it very tightly so that it effectively becomes very pointless, or we can open it very wide so it becomes basically unlimited, unbounded on the other end. So it's this issue of, well, what does with the leave of the court mean? What kind of leave are we trying to get? What kind of things can the court do and what can't they do? And so that's the issue. So we're on a writ of mandamus, which is a writ to order, a writ to mandate. So a writ of mandamus is a order from a court to a lower court or to some other body to either do something or not do something. It's an order to do something or not do something. And so we want a writ of mandamus because both the government and Michael Flynn, so both the government and the defense, want this case to go away, and the judge doesn't. So our remedy here would be a writ of mandamus, which is, please direct the court to dismiss this case, or not. Let us know one way or the other. So we're going to listen to some of this oral argument and try to figure out what with leave of the court means. It has some kind of meaning, but we're not sure. So let's listen to this and try to figure all that fun stuff out. How exciting is this? And of course, we don't have video because it's the United States courts. But what we do have is a fun image of the court building. And we do have some audio, and we have some YouTube closed captioning. So we're going to go with that. Let's give this a try.
On ears and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-5143, in re Michael T. Flynn. Ms. Powell for the petitioner, Michael T. Flynn. Mr. Wall for the U.S. Department of Justice. Ms. Wilkinson for the respondent, the Honorable Emmett G. Sullivan.
Good morning, counsel. We'll hear first from Ms. Powell.
Good morning. May it please the court, this is Sydney Powell for petitioner Michael Flynn. We are here now to stop further impermissible intrusion into the sole power of the executive branch under the Take Care Clause to decide to dismiss a case and what circumstances warrant that dismissal. The government here provided an extensive and thoroughly documented motion to dismiss this prosecution, weighing as it should all the factors that go into that, including the provision of extraordinary exculpatory evidence that came to light through an independent review by Mr. Jensen, who not only had 10 years experience as an FBI agent, but 10 years as a federal prosecutor before Attorney General Barr tasked him to review this case. It cannot go on any longer. This is the quintessential case for Mandamus because we have both issues of judicial usurpation of executive prerogatives and a clear abuse of discretion. The judge has no authority to do anything further in the case. There's no case or controversy any longer. The parties have decided, the government has quit, and he also has no...
The no case or controversy thing is pretty important because, of course, Article 3 of the Constitution only gives the courts the authority to hear, the federal courts, to hear cases and controversies. That is actual live disagreements. So if there is no live disagreement, then that becomes a jurisdictional issue for the court. So the idea that there's no live controversy anymore, maybe the right way to frame this is just as an issue of jurisdiction. So maybe there's no jurisdiction anymore. Yeah, that could be that makes sense.
Authority to go into the reasons behind the executive's determination to dismiss the case. It's over.
Also, this is Judge Wilkins. Good morning.
Good morning.
I have a question about the role of the district court. You essentially argue that the district court has no role, but in Rinaldi, where the Supreme Court was reviewing the denial of a Rule 48 motion made by the government, the court did what it called a, quote, independent evaluation of the unusual circumstances disclosed by the record. So the Supreme Court believed that it had a role to perform an independent evaluation. So doesn't the district court here have that same role?
Not in the circumstances of this case. The authorities are that given the fact the presumption of regularity applies to everything the Attorney General has done, and there is no clear evidence whatsoever to go behind that, given the documentation, reasoning, and briefing that has been provided, there is nothing further for the court to do. There's no indication, there's no clear evidence, there's no actual factor or reason to go behind the government's determination of the factors.
I don't see how that works, because
I don't quite see how that works either. That's not quite the question that was asked. It's not quite the question that was asked. The question that the judge asked was, in this other case, the Supreme Court looked behind the curtain. So doesn't the district court have the right to look behind the curtain? And her answer is, effectively, well, they shouldn't look behind the curtain, which is a different answer. So it doesn't quite track. Yeah. So yeah.
The court also said in Rinaldi that it would not presume bad faith by the government. So the court gave the government the benefit of the presumption of regularity, but it yet and still performed an independent evaluation.
Only to the extent the court said it was not clearly to the contrary to the manifest public interest. There was no further proceeding of any significance, certainly no amicus appointed, certainly no factual background investigation in Rinaldi. It was simply a review of the Petit policy and its application to the facts of Rinaldi. And in Fokker Services, this court issued the Mandamus, of course, to proceed to make sure the deferred prosecution agreement was entered. And in doing so, it said the leave of court authority gives no power to the district court to deny a prosecutor's Rule 48A motion to dismiss charges based on disagreement with the prosecutor's exercise of charging authority.
Let's suppose the district court had issued a minute order saying that it intends to do an independent evaluation of the record and will issue an opinion on the government's 48A motion in due course. Is that error?
I think that is error. I mean, he can look at it on the face of the documents that have been filed, but I don't think in Rinaldi that they went farther than the government's statements of what it was doing and why it was doing it. Only the executive can weigh the willingness of the government to prosecute, and there would be no remedy. I mean, the court can't make the government prosecute this case.
Well, in Thompson, another Supreme Court case that was cited by at least the government in their briefing, I can't remember if you cited it in yours also, the Supreme Court was reviewing a denial of a Rule 48A motion by the government, and it said that it performed, quote, an independent examination of the record, close quote. And that was despite the Solicitor General's suggestion that the court just simply dismiss the case. Do you disagree that that's what the court said that it did in Thompson?
No, but I think all that means is reviewing the documents that the government provided and the existing status of the record before it. not investigating new possibilities or assuming the role of the prosecutor to see about adding on perjury or contempt charges. He simply doesn't have the authority to do that. And without a case in controversy, he's without jurisdiction to do anything further. I mean,
well,
if we were here...
Your mandamus petition is the rulings under review are the failure of the district court to grant the motion. So you believe that just him not granting the motion is sufficient grounds in and of itself to justify mandamus, right?
Well, in Fokker, the court also said that the court's withholding of approval would amount to a substantial and unwarranted intrusion on the executive branch's fundamental prerogatives, and the judiciary's lack of competence to review the prosecution's initiation and dismissal of charges, according to Wait, equally applies to the DPA decision. So either way,
so you believe that Fokker, a case that was not even a Rule 48A case, undermines what the Supreme Court did in Rinaldi and Thompson when the Supreme Court itself performed an independent evaluation of the record, when there was no argument there that there was any bad faith by the government or that the presumption of regularity didn't apply? You think that Fokker said that the Supreme Court got it wrong in Rinaldi and Thompson?
No, I'm saying that the independent review of the record consists of just that, a review of the record. And the record in this case is extremely well documented of prosecutorial misconduct and the suppression of Brady evidence that warrants dismissal under any circumstance, aside from the fact we have had motions to withdraw pending that were very well documented. I mean, this record contains enormous evidence now of government misconduct and the suppression of Brady evidence. It's just that the judge he doesn't have the authority to appoint an amicus under the Smith case that Justice Ginsburg just wrote the unanimous decision for. He can't go out and create new issues. Of course, he can look at the materials before him, and we welcome him doing that. But to go ahead and grant the motion, because there's no other alternative, not a single case in the country has ever affirmed the denial of a motion to dismiss under 48A.
All right, so a couple things of note that are pretty interesting here. So there's a little bit of dispute. It seems a little bit of dispute when the Supreme Court was talking about these other cases and was saying it was doing an independent evaluation. What exactly does that mean? What was the Supreme Court actually doing when it was conducting this independent review? And so there are two possibilities, presumably, that we are reviewing the record as it exists, or we're looking to expand upon the record. And you would expect more of the former rather than the latter, because the Supreme Court doesn't expand the record. You know, they look at the record before them. They don't usually go out and find new stuff. So there's this question from this judge a couple times about these cases and what it means to be conducting their review. Does it mean just merely look at the documents that are there, with some sort of additional thoroughness, or does it allow for more than that? So that was a operative question. What was the Supreme Court actually doing in these cases when it was talking about that? So that was a pretty interesting exchange on that. And so the lawyer is saying, well, when they were writing that, what they were really doing is just looking at the record, and they weren't doing anything more than that, which seems plausible because the Supreme Court, of course, is a court of review, and you would expect they're looking at the record as it exists, not to do something more. So that makes sense as an answer in terms of what the Supreme Court was actually doing. Tony said these judges are good in trying to trap her. I disagree with your read on it that it was intended to trap or is a trap. And these seem like perfectly legitimate questions to me. There is some language in some Supreme Court cases that seems to suggest one thing, and they are perfectly valid questions. The first answer that the person gave was not really a good answer, because the first answer was, well, can they? And the answer was they shouldn't, which isn't the same thing. So the judge asked the question a second time because he didn't actually get an answer the first time. He's like, well, can they? And then there was this exchange over what these two cases were and what the Supreme Court was talking about. So I didn't see it as an intent to trap or anything like that. It's like it was more about trying to get an answer to the question that was actually asked. And I thought the second time and third time when they're talking about the two cases, and the second time he asked about one case, the third time he asked about a different case that's related. And I thought she gave better answers. So I didn't very much like her answer the first time. I liked her answers the other two times better. So, so. Yeah.
Then it seems like you got a pretty good argument that you have an alternative avenue of review. Then if he denies the motion, then you can come back here on appeal, and you can cite all of those precedents to our court, and we can decide that issue at that time.
But he doesn't have the authority now to go beyond the record and do anything except that. We would simply be delaying the inevitable and going through an inordinate process in the process of doing that. I mean, we just got dumped on a 72-page brief that we have to answer by Wednesday with 500 pages of exhibits. Everybody else in this case is being paid by the government except my client's defense team. The toll it takes on a defendant to go through this is absolutely enormous, and it's not justified by this case. This is the most impressive motion to dismiss I've ever seen in decades of practice, and the most well-documented. And in fact, in Judge Leon, I think it was a 2-page motion to dismiss, pursuant to which he dismissed 3 defendants for the government after guilty pleas just a couple of years ago. And of course, in the United States, the government dismissed, and Judge Posner wrote that decision explaining how the special prosecutor's position had to be vacated and the motion to dismiss had to be granted on mandamus.
Ms. Powell, let me ask you, this is Judge Henderson. If Judge Sullivan had just kept this motion waiting and languishing, it'd be one thing. He has set a hearing for mid-July. For all we know, by the end of July, he will have granted the motion.
But he doesn't have the authority to conduct that hearing, Your Honor. He has appointed this amicus to go far beyond the scope of his authority as a member of the judicial branch into the prerogatives of the Department of Justice.
I realize that, but you also know that the courts have said he's not merely a rubber stamp either. So there's nothing wrong with him holding a hearing as far as I know. I don't know of any authority that says he can't hold a hearing before he takes action.
Well, the only authority that their best case is in Ray Richards, in which the Third Circuit, on a motion to dismiss a sexual misconduct claim against someone in the Virgin Islands in a territorial court, said we got to have a little sunlight on the reasons here because the only reason given was in the interest of justice. And certainly that's not sufficient. But even that case, it was actually altered by the court's decision or discussed by the court's decision in HSBC Bank, the case out of Mr. Gleason's court that reversed his overreaching authority on reviewing a 48A dismissal. And that HSBC case describes Richards as requiring a 48A dismissal because the district court's authority severely cabined the review to clearly contrary to the public interest, meaning the prosecutor acting in bad faith, such as bribery, fecklessness, animus to the victim, or his own self-interest, things like that. And there is none of that here. If Judge Sullivan had denied the motion to dismiss on this record, we would be entitled to mandamus right now. To drag this out another 6 months, I mean, it won't just be a hearing on July 16th. It'll go beyond that. I think it's clear from the amicus position now that they want to take General Flynn to sentencing as soon as possible and impose upon him the maximum possible sentence. And to make us go through that process when the ultimate result has to be the grant of the motion to dismiss, the government's just wasting resources out the wazoo pursuing this. And the toll it's taking on the defendant is certainly irreparable harm.
I'd like to ask you, go ahead.
Let me ask one last question, and that's, why couldn't we hold this in abeyance and let's see what happens on July 16th.
Because the damage continues to accrue by the day, because he has no case or controversy before him and no jurisdiction, because he doesn't have the authority to go do what he's trying to do or has done. He didn't even have the authority to appoint the amicus under Justice Ginsburg's decision.
I don't understand that argument. I mean, suppose in a run-of-the-mill criminal case, well, it's not run-of-the-mill because the government has evidence from a drone camera that was positioned to look through upstairs bedroom windows into the defendant's home, and the defendant moves to suppress, and amici, including the Cato Institute and other organizations, seek to participate as friends of the court in support of that motion to dismiss. You're saying that a district court wouldn't have authority to grant those motions?
No, I'm saying that he doesn't have authority to appoint an amicus to do the job that the government would have done if the government chose to continue the prosecution.
So the court can appoint amicus on the motion, but the court can't do it on its own motion?
No, I'm saying that the court cannot substitute its role for that of the government. It can't take the place of the Attorney General or appoint someone to take the place of the Attorney General. That's precisely what Judge Posner rejected in Writ, United States. He can't go outside his lane to appoint somebody to do the job that
the order appointing amicus appointed him to present arguments in opposition to the government's motion to dismiss. That's all that it says in that paragraph. So how is that violating Article 2 to appoint someone to present arguments in opposition?
Because the government had already made the decision to stop, and the government is the only entity that can make that decision. The Department of Justice is the only entity that can decide whether to pursue this prosecution. The judge has no way of doing that on his own through amicus or a special prosecutor or anything else. The government has quit, and it's time to leave the field.
Ms. Powell, what about, sorry.
Go ahead.
What about, this is Judge Rao, what about appointing amicus for the contempt charges? Right, I mean, the Supreme Court in the Young case said that the court can appoint a private party to prosecute contempt charges. I mean, do your arguments with respect to the appointment of the amicus apply also to the contempt charges?
Yes, as our amici pointed out, and we did also in our brief, contempt doesn't lie for perjury in these circumstances. There are 500 people in the national database of registry of exonerations who would otherwise be susceptible to perjury prosecutions because they entered guilty pleas, but they were actually innocent.
But Ms. Hall, that goes to the merits about whether contempt could actually be found. But what about the appointment of the amicus to look into contempt charges?
There's no basis to do that either. He doesn't have the authority to prosecute anyone for contempt. That's not the judge's place to add on charges. That is solely within the prerogatives of the Department of Justice.
But isn't that inconsistent with the Supreme Court decision in Young?
I don't see that inconsistency.
Well, in Young, the court said that the district court can appoint a private party to prosecute contempt charges.
Well, in the circumstances of this case, contempt cannot lie by virtue of him having moved to withdraw his guilty plea.
Well, let me ask you one other question about the contempt charges. I mean, if we decide that reassignment here is not appropriate, would we have any grounds for reaching the contempt question? I don't believe Mr. Flynn's petition for writ of mandamus asked for mandamus on the contempt question itself. Is there any grounds we would have for being able to reach that question?
Well, simply the fact that the judge doesn't have the authority to do it and there's no continuing case or controversy.
Can I ask a question about the continuing case or controversy point? In Thompson, the 1980 Supreme Court case that I referred to earlier that was cited in the briefs, the Supreme Court, the Solicitor General suggested to the Supreme Court that the case be dismissed under Rule 48A. And the Supreme Court did not itself dismiss the case, and the Supreme Court did not declare that there was no longer a case or controversy. Instead, the Supreme Court remanded the case to the Court of Appeals for reconsideration in light of the government's present position. So, in that case, the Supreme Court did not treat the fact that the government had filed a Rule 48A motion as ending the case so that there was no longer a case or controversy. Don't you agree?
Well, if I recall that case correctly, it was a mandamus for a mandamus. And what the Supreme Court decided was that the appellate court needed to address an additional issue. That is not our situation. With the fact that not a single court in the country has ever refused to affirm a 48A motion, there's no basis to proceed with this case. The government is the only entity, the Department of Justice is the only entity under Article 2, Section 3 that can prosecute the case. And they have decided not to do this for a number of reasons, not the least of which is the appalling suppression of exculpatory evidence that's gone on for as long as 3 years. The fact that the FBI agents literally made up statements to put in a 302. The fact that Mr. Priestap had a discussion with Andrew McCabe about trying to get the defendant to lie and, what is our goal here, and came back the next day reconsidering the fact that they had decided not to show him the evidence that they had like they do with everybody else. The fact they decided not to even give him a 1001 mention, not even a warning, of course. No warning, but not even to mention 1001.
So that's an interesting little thing there. I don't know on the law in terms of whether it's required or not, but very typically when the federal government is interviewing you, they'll give you a warning. So she's saying, well, they didn't give him a warning first. So she's referring to 1001. You heard her say that, right? 1001 warning. Okay, so the statute she's referring to is 18 U.S.C. 1001. That's the one that makes it a crime to lie to the federal government, including the FBI, but any of the federal government will be fine. It's the one that makes it a crime to lie to the federal government. And typically they will warn you first. They will say, okay, just to remind you, it is against the law to lie to a federal official under 18 U.S.C. 1001. And so normally they will do that. Now, what makes it interesting is, and again, this goes to my understanding of how this is done, but because I've never had it come up to me personally, right? But normally, when this is done, they do it just before, like immediately after they think you lied. And so they're going to ask you the question again. So normally the way this is happening, as I understand it, you have a discussion with the FBI, which by the way, don't do that. But you're having a discussion with the FBI and you say something and they think they caught you in a lie. So normally, as I understand it, what they do is they give you a warning. They say, okay, just to remind you, lying to a federal official is against the law. Because it goes to mens rea, mental statements, right? So one of the reasons that you might want to do this if you're the police is to make the intent easier, right? So like having reminded you, now I can make the intent easier. So it makes the mental state easier, right? So, maybe you lied with intent, but if I actively remind you, so this again kind of somewhat parallels. Obviously, the analogies break down rapidly, but it somewhat parallels to the intent ideas for the cop with George Floyd and the knee on the neck and why we might be able to get to intent, right? The very fact that people are actively warning him at the time as it's happening makes the intent a lot easier to prove than if those things didn't happen, right? So you're actively being informed about it, so the intent becomes easier. Not easy, but easier, all right? So back to the current situation, same kind of idea. So as I understand it, if you're talking to the FBI, don't do that. If you're talking to the FBI and they think they catch you in a lie, they'll give you this warning, so that if you lie, they can make it easier to show, oh, it's with intent. Now, what I understand happened in either Michael Flynn's case is either A, they didn't give the warning, or B, they gave the warning at the very start of the conversation, like right up at the top of the entire discussion, which again is not normally how this is done. Normally, as I understand it, it's given like just before the moment of truth. So she's like, oh, well, she says we didn't get a warning, which I think is disputed. But they didn't get a warning like at the proximate time. I think that's clear. But anyway, that's what she's talking about in terms of that 1001 warning. So yeah.
Agents over there, according to
a first-year prosecutor could not get first-degree murder in Floyd. No, you can't get first-degree murder in Floyd because you can't show premeditation. I think that's going to be impossible to get to premeditation. You have to show premeditation and intent for first degree. No, and intent is tricky. So second degree, I think, is tricky. That's also why the prosecutor so far has charged felony murder, which I think doesn't work. But no, I don't think you can charge first degree murder because you can't show the premeditation. You can't show a planning and deliberation in advance. I think first degree murder is right out. And second degree murder has its problems because intent to murder is pretty tricky. So, it's challenging.
Mr. Comey's testimony just told him a couple of agents were going to drop by. Was that okay? And he said, of course, sure. He works with them all the time. I mean, this is an appalling injustice. It's a travesty of justice that this man has been dragged through this for 3 years on a case that was absolutely concocted by FBI agents with some help from the Department of Justice, and evidence falsified and everything else. The government has provided extraordinary documentation, and the only thing left to do is for the judge to order the dismissal of this case. The delay—
You can't do an independent evaluation of the record before entering that dismissal.
No, he can look at the record. He can look at the record, but the only thing to do as a result of that is to order this dismissal because of the presumption of regularity that attaches and the fact there's no clear evidence of anything else. He can't make up these things he calls reasonable, plausible questions that don't even relate to the motion to dismiss and proceed to drag this out forever. It's just not— I mean, it's contradictory to Fokker Services. It's contradictory to Rinaldi. It's contradictory to the NRA United States and the Fourth Circuit in Smith and the Fifth Circuit in Ham.
Where in the orders under review did the district court say anything about reasonable, plausible questions?
It's in their brief.
That's not the order under review, though. The order under review is, from your perspective, is him not granting the motion. That not granting the motion itself is grounds for mandamus.
And appointing the amicus to do anything. But yes.
So we have to find both of those things to be improper to justify amicus. Is that your position, or is any one of them by itself grounds for mandamus?
I think either one by itself is grounds for mandamus. They're independent grounds for mandamus.
Ms. Powell, let me ask you something about this appointment of amicus. In Fokker Services, we ourselves appointed amicus. Now, if Judge Sullivan had not appointed amicus, would you be telling us that we couldn't appoint amicus?
No, ma'am. You can appoint amicus to weigh in on any issue the Court of Appeals wants an amicus to weigh in on, as long as it's an issue within the case and the Court of Appeals didn't create it. What Judge Sullivan has done here is created his own issues that he wants to investigate that aren't related to the motion to dismiss or even the case before him in any way.
Yeah,
wants
that's
to add on the
I
charge.
I like that answer. That's a pretty good answer. So yeah, so she's basically saying, yeah, you can have an amicus if there are actual issues, but you can't generate issues. You can't manufacture issues as a court. That's a pretty good answer. So yeah, you can have an amicus on any question that's before a court, but you can't, as the court, create questions. So if there's no dispute, then you don't have a power to create an amicus. You can't go ghost hunting. I like that answer. It's a pretty good answer.
But in
That he can't.
But in Fokker Services, we appointed someone to defend Judge Leon's order. And this is what Judge Sullivan...
That's what Ms. Wilkinson is doing here before this court. She's the analogous piece of that proposition, not Mr. Gleason.
That's true. And you have no problem with her, obviously.
No, obviously she's entitled to be here on behalf of the judge. Appellate courts often allow amicus participation, but the district court doesn't in criminal cases. There's not even a provision in the rule for that. In fact, if you go try to file a brief as an amicus in the district court, you can't do it properly.
The idea of an amicus in a trial level criminal case is pretty weird. Yeah, especially that's so. Yeah, amici in appeals, no problem. In a civil case, yeah. In a criminal case, it's pretty weird. So she's like, yeah, there's not even a rule for it. If you wanted to intervene, if the judge wants your help, they can ask. But if you want to intervene into a random criminal case, there's not even a rule for it. So there's, it's a little weird to have an amicus in a criminal case at the trial level. That's pretty strange.
Docket entries had to be corrected. There's no provision for amicus in criminal cases.
So I asked you earlier if an amicus could file a motion in support, a brief in support of a motion to suppress. What's your answer? Is there authority for that, yes or no?
I would think there's authority for that.
Based
in
on
support
what?
of a motion that another party has filed. If the judge wants to allow it, it would require leave of court, I would think.
Based on what rule?
I don't think there's a rule for it, but I do believe that, for instance, there have been amici in other cases in the district court level.
So the judge just caught her out on a logical contradiction. So good for the judge and bad for her. Yeah, they caught her out on a logical contradiction. She says, oh, there's no rule for it. And just says, wait a second, no. I asked you earlier about about an amicus in a motion to suppress. And you said, okay, so what's your answer now? Yes or no? And she says, well, I think so. Based on what authority? Well, I don't know there's a rule for it. Uh-oh. Yeah, you've run into a logical problem. Yes, they can do it, even though there's no rule for it. And therefore, they can do it because there's no rule for it. Ta-da, right? So, yeah, you run into a logical problem. Oops.
But it's been in support of a position of one of the parties, not in support of a judge trying to gin up additional charges himself.
Okay, and that is a point of differentiation, but she's having to save herself because she created a problem. Now she is trying to save herself, and she has a good idea to save herself, but she did create the problem because initially said, "Oh, there's no rule for it." It's like, wait a second, yes there is, because you said earlier, like, oh, okay, let me try a new idea. Yeah, let me try a new idea. There's no rule for a judge to manufacture a question. So yes, you can have an amici. You can have an amici answer if you with leave of the court in a criminal case if the parties allow for it. So the parties need to consent. Okay, and the judge wants it. Yeah, you can do that. But what you can't do is manufacture an issue. So if there are no issues, if you can, again, because this goes to jurisdictional issues, it goes to Article 3. Standing and jurisdiction issues. It goes to fundamental case and controversy questions. The federal courts can only hear cases and controversies. They can only hear disputes. They can't do hypotheticals. So, on a straight her best argument is essentially constitutional. Essentially her best argument is constitutional. Yeah, the executive has the authority to decide who to prosecute or not under the Take Care Clause. And having made that decision and there's no dispute between the parties, there's no case in controversy, so the court no longer has jurisdiction. And so there's nothing left for them to do but dismiss. And so she caught herself in this little problem with the amici and when amici can and cannot enter. So she lost a little bit of credibility and she made a misstep there. But she has a better idea. The better idea is the judge can't manufacture issues. They can't create issues. So they can only adjudicate the issues that the parties present. And if both parties say we're done, then we're done. So yes, you can have an amici if there's an issue and the parties agree and blah, 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 but not here because the judge is the one manufacturing it. Okay, so she saved herself. All right, cool.
Well, just with respect to the Rule 48A motion, it's your contention that if, for some reason, Mr. Flynn opposed the government's motion, it would be okay for an amicus to enter an appearance to file briefs in support of Mr. Flynn, right?
Well, at least there would still be a case in controversy before the court, and it would be up to the district court whether to allow leave to do that. I don't see a provision in the rules for it, but generally speaking, district courts I've known kind of do what they want to do within bounds of reason.
So there's authority for it so long as there's a case or controversy? Is that, I'm just trying to understand your legal reasoning here.
The legal reasoning is that he essentially appointed Mr. Gleason as a special prosecutor, that he doesn't have the authority to do. If he'd asked Mr. Gleason, for example, to weigh in on a side that existed in the case, that might be permissible. I would probably still argue against it, but I wouldn't have sought a writ of mandamus on it, I don't think. But to bring in...
Isn't your argument also that it's impermissible to have amicus briefs in criminal cases under the rules of the court?
Yes, that is one of our arguments here because there is no rule providing for it. But like I said, I've certainly seen it done in other districts' courts as long as it's on the side of one of the parties that seeks to continue the litigation, just not on behalf of the judge as an independent prosecutor himself.
All right. Are there any more questions? Okay. Ms. Powell, we'll give you a couple minutes in reply. Next is Mr. Wall.
All right, so we're just going to pause right there real quick while we invite Nate in, since we have a nice little break here between the attorneys speaking, because apparently we're going for 2 hours for some reason. I don't know why. Why is this oral argument so long? Someone has to explain this to me. Why is there 30 minutes per side? Why has she been speaking for 27 minutes on a writ of mandamus motion? Why is this a thing? And why is there hour 47 of total audio? But let's look past all those issues as we invite Nate into the chat, and just look past why are we doing this to ourselves? Yeah, why are we doing this to ourselves as we try to figure all that wonderful stuff out? Good times. Good super times, yeah. Yeah, then I have to figure out how to, okay, this is going to be interesting on many levels. You guys get to watch me try to figure out how to make this work in real time. Super exciting YouTube stuff. Talks amongst yourselves. Where is my chat? Okay, yeah. Yeah, we're here for a little bit, yeah. We are here for a little bit, yeah. We're not going anywhere in a hurry. We're just waiting for Nate to join. So while I'm waiting for Nate, I'm going to change my camera setup. So let's see. Let's see how I actually do that. All right, so first I'm going to remove my camera. So you're going to see a big black nothing. You ready for this? Very exciting. All right, so now you have a big black nothing. That was great. Now let's try adding this in and see what happens. Okay, wow, that was definitely not what I was hoping to do. Okay, let me think. I don't know if I can do what I'm trying to do. I don't know if I can do what I'm trying to do. As long as I turn off the virtual camera. Yeah, I just have to turn off the virtual camera and use a different camera instead of the so I have to stop this camera and I have to change the camera and change it to the game capture camera. I think I have to get out of this thing completely, and that's nice. So hold on. Enter broadcast studio. I want to change the camera, change it to this, change it to this. Okay, that works. Good. Enter broadcast studio. Okay, that works. And okay, now we have a much wider shot of me. And we have Nate. Ooh, exciting. Now I can go over here, turn this off, turn this on. Ho 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 ho. Ho ho ho, victory. You're very much on, by the way, Nate, just in case you were wondering.
Oh, cool. People are going to see me messing with my hair.
Yeah.
I look horrible. What's going on today, man? I see we're back to Michael Flynn stuff, huh?
Yeah, we're trying to figure out what the law is, and it's very, very confusing stuff.
Oh yeah, it's incredibly confusing. I've been looking at this stuff like all week, and it's just like, what is going on? But it's all unprecedented. The fact that he's pleaded guilty, they entered the plea, he's convicted more or less, and now they're saying
I think convicted
they don't have enough information to convict
convicted is the right word, yeah, because he's pled guilty, so that qualifies as a conviction, right?
Yeah, no, he's convicted. He's convicted, and now you're going back and saying, well, we don't have enough evidence to convict him. Like, what? Huh? What? Did you not know what just happened like 2 weeks ago? Like, he said he did it, and then you got this weird thing where he lied to the FBI. Then he says he didn't lie. Then he admits to lying to the FBI. So now he's lying. He lied. Then he's now saying he lied not about lying. It's crazy. Which is the truth? But I do think this judge did something very, very special, and I don't know.
Oh no,
it's legit or not.
It is all the special, but it's just part of the continuing special. No, it's definitely special.
Yeah, it's special. Oh yeah, it's special. So you just got, from what I caught it at the tail end, maybe like the last 10 minutes.
We've got past we've got past the first person's argument. Is where we are.
So have you ever argued in front of an appellate court?
I have not had the pleasure, no.
Well, the way it usually goes is that you'll get, they have a set amount of time, like you'll get 30 minutes or even like 45 minutes, both sides, and then you can reserve some time for afterwards. So like when I did it, it was, they give us both 30 minutes, and then reserve some time for rebuttal. The person who's making the argument. So usually you can reserve up to 2 to 5 minutes. It's pretty cool. And then it's like, it's not a presentation. It's more like an interrogation by the 3 judges. Like,
right.
What the hell are you talking about? So.
Absolutely. So now I've got you with picture in picture. Ooh, cool.
You're like the OBS master.
We're all sophisticated over here in YouTube land. I'm the best YouTuber. I am the greatest YouTuber of all the time. Yes. All right. So where did I leave my chat window? That's the next question. Okay. So we are now here with Nate. Yes, I think she saved 4 minutes. I don't understand why we're here so long though, because normally in appellate courts, I think isn't the standard rule like 15 minutes per side on appeal in federal court?
I'm not sure.
Yeah. So why is she speaking for a half hour, and why is there an hour 47 of audio in an appeal? This should not be a thing.
This isn't. I don't. This isn't an appeal, isn't it? Isn't it a mandamus? They're asking
Yeah.
for a writ of mandamus, right?
Yeah.
So
You think
yeah.
writ of mandamus is you get extra time? Okay, let's go with that. Why not? Yeah.
No, maybe because you're literally asking the appellate court to force the district court to put in an order for something. So I would suspect you may need more time. I don't know.
All right.
The elusive writ of mandamus, and just for you law students out there, writ of mandamus was the most famous case that had to deal with a writ of mandamus.
Ooh, trivia question.
It's the most famous case in the U.S. in U.S. history. I would suspect.
The most famous.
And it was all about a writ. And it's all about a writ of mandamus.
Well, I can think of probably the one you're alluding to. Should I give my answer?
Of course.
I'm going to go with Marbury versus Madison.
There it is. Writ of mandamus. There it was. That was the whole case about, and gave us judicial review. So we went from writ of mandamus to judicial review.
That's
so
right.
That made happen
yeah.
here.
We used we used a writ of mandamus to create court authority in the first place. It's magic. We want a writ of mandamus to create the entire concept of judicial review. That's the best writ of mandamus. Yeah. We'll give you mandamus. We'll give you mandamus for days, or more to the point, for 2 centuries.
Oh my god! So let's get back to the oral arguments.
Yes,
man.
let's get back to oral argument.
What's going on?
Yeah. So here's how I summarize her argument. Her argument, as best as I can understand it, is yes, in general, you can ask for amicus, but what was special here is the judge is manufacturing issues. So this is unlike a motion to suppress, where one side or the other is raising the issue and they want some additional help on that issue. The thing that's distinct here that makes it improper is the judge is manufacturing issues, creating issues that are not brought by either party. And that's what makes it improper. And her best argument here is essentially jurisdictional. Because there's no case in controversy, there's no Article 3 jurisdiction for the courts. So that's how I summarized her. I just did her entire half hour in about 30 seconds.
I think the strong points of the arguments that from what I heard was one, that this was kind of like a special prosecutor, right? Because there's no contention between there's no controversy. Obviously, the no case in controversy is I think the strongest argument. It's a very strong argument. But then the other piece of the argument that I like is the way she's narrating it, the way she's presenting it as this is an overreach of judicial authority in this, and that's why it needs to stop. So I really like, and I like the judge's pushback, but I think she has you can't laugh her arguments away. I think they're they're legitimate arguments.
She did run into a logical problem where she argued herself into a corner, but she got out of the corner, so it didn't matter too much. But let's continue and see what we got from Mr. Wall, I guess is his name, what Mr. Wall wants to teach us.
Thank you, Your Honor. And may it please the court.
Can you hear this audio, by the way?
No, but I can hear it on the YouTube side, so don't worry about it.
Questions that the court has asked petitioner's counsel, but I want to start with 2 points. One on the merits to you, Judge Wilkins, and one on harms to you, Judge Henderson. And I think, by the way, that's the right order to take them. In recent mandamus cases like Fokker and like Blumenthal, the Emoluments Clause case, the court looked at the merits, asked whether there was a clear and indisputable right on the merits, and then turned to the mandamus factors and the harms. I think that makes particular sense here, because if we're clearly right about Fokker, that it doesn't leave an oversight power in the courts or a substantial role with respect to unopposed Rule 48 motions, then I think it's easier to see, Judge Henderson, why it's so harmful to continue to allow this process to play itself out in the district court. Taking the merits first, Judge Wilkins, Rinaldi was a case in which the court assumed, and I think it's clearest in footnote 15, it assumed the broader standard and then said that even that standard can't be satisfied, so the trial court has abused its discretion in denying a motion. A motion, by the way, that came after judgment in that case, not just after a plea or a trial, but after judgment. And Thompson, of course, was just a case in which we wanted to pull the prosecution in the Supreme Court and asked the court to GBR. And even there, after an affirmance in the Court of Appeals, it sent it back to the district court to allow us to do that. But I completely grant, Judge Wilkins, neither one of those cases resolves the substantive standard for Rule 48. They resolve that Rule 48 applies, contra respondent's assertion, all the way on direct review. There's no magical line at the plea, but they don't resolve the substantive standard. The case that does that, and the case that we rely on for mandamus here, is this court's decision in Fokker. That's the decision that resolves the substantive standard for the denial of a Rule 48 motion.
How does it resolve that when?
I mean, it's at least not. I think the YouTube audio is a bit behind me, but anyways, it's not immediately clear that Rule 48 doesn't have some delineation at certain points. Like he says, oh, the rule applies at any point, and at that point is not inherently obvious. You know, it could be the case that once the plea is accepted and stuff, and we're essentially in a sentencing phase, you know, that some of the authority to dismiss may disappear. The idea that the court has gained the jurisdiction, you know, like your butt is mine now kind of idea. So, you know, that now if you have confessed judgment and you were before me, you know, this is now my blah. So the idea that the government has the authority to dismiss after sentencing is not inherently obvious.
Yeah, it's interesting because I don't believe the government has the ability to. The way, just to educate the fan base, there's usually two phases to the trial. There's the liability phase and then the sentencing phase. In criminal court, that's criminal liability and sentencing, and in civil cases, that's liability and damages. So you have those two phases. We have to prove damages in the second action after, you know, but it's all considered one trial. So in this particular case, the trial portion is over. Like the prosecutor, after he's pleaded guilty, the prosecutor can just walk out the building, right? It doesn't matter. He doesn't have to advocate. No, but he doesn't have to advocate for anything, right? Because the only thing now, the prosecutor is advocating for more time or less time, but it's not his decision. You know, he doesn't have, if the prosecutor was to leave at that point in time.
That's right. I'm out. I'm out. I'm out. You figure it out. You don't need me. I'm out. You guys figure it out.
We found him liable.
That's right.
We found him liable.
You guys don't need me here. Yeah, I like it. Yeah.
So I'm just trying to figure out. They're right. At this point in time, there is no case of controversy because the controversy is ended. Now we're talking about sentencing. So I'm interested to see how this person resolves the Fokker issue, because Fokker wasn't about after sentencing. Yeah. It was really about. It was during the investigation phase, right? It wasn't even about. You know,
I feel morally obligated to make as many meet the Fokker jokes as possible. Also.
Oh my God. Poor Fokker.
The case was not an appeal
but Fokker won,
of a Rule 48A motion.
Because what Chief Judge Srinivasan did in discussing the DPA was he explained how DPAs and Rule 48 motions are analogous, and he separated off approval of a plea agreement under Rule 11. And that analogy was central to the court's reasoning, right? In order for the court to say that district court erred in a way that justified mandamus, he said the error is so clear because look at what has to be the rule under Rule 48, and then that has to be the rule for DPAs as well. So I understand parts 2A and 2B of the opinion in Fokker to be central to the judgment and to what it goes on to do when it applies that standard later in the opinion. And I think the language of Fokker, when it goes through that discussion, leaves no doubt. It says dismissing charges, not just commencing, but dismissing, is squarely within the ken of prosecutorial discretion. It says there's no oversight power in the courts, no involvement by the judiciary, and it says no substantial role for courts. And if we're right about what Fokker says with respect to Rule 48, then to turn to my point to you, Judge Henderson, then it's really a question of what are the point of further proceedings if the district court is required by circuit case law to grant the Rule 48 motion. And
you believe that Fokker stands for the proposition that the district court can't perform an independent evaluation of the record?
I think it does in the following sense, Judge Wilkins. I understand Fokker to mean that if tomorrow, faced with the kind of ruling agreement that was at issue in Fokker, a district court said...
Whoa. The audio just cut out. Oh, that's not me.
I'm going to set up a process for deciding whether to grant this agreement. We'll hear from both sides. There are a number of factual questions I'm going to have to resolve about whether you've gone too easy on particular defendants. And the district court did all of that. I understand that to be, yes, a straightforward violation of Fokker. And again, it's not just the sort of idea that there will be some briefs and a hearing, Judge Henderson. The harm is that, as the respondent explains, both in the opening brief and page 2 of the reply, the point of this is to investigate, they say, the prosecutorial decisions and prosecutorial motives. Those are respondents' words.
The order itself says that which is under review.
Oh, you're trying to do it so I can hear it through the stream.
Yeah. This is appointed to present.
Just share audio. Did you share the screen?
The government's motion to dismiss. That's the order under review. So it doesn't say anything about, fact development or anything else.
So with all respect, Judge Wilkins, 2 points. First, we're not here on appeal from an order. We are here, as you know, on Mandamus, and Mandamus is an extraordinary writ that directs the district court to do something. It's not necessarily a review of an order. And here we're asking that the district court be directed to grant the Rule 48 motion. But second, beyond the order, the reason for entering the order, as respondents' briefs in this court have explained, so we now know what's going to go on below. Respondent wants to inquire into what they say are prosecutorial decisions and prosecutorial motives, because the district court is concerned that there was improper influence here, and indeed both the district court and the court-appointed amicus have, on the one hand, suggested, and with respect to the amicus, flat out alleged that there was misconduct on the part of the Attorney General and even the President of the United States. That's going to mean that we are, in the district court's view, going to have to come in and answer those questions and defend against them. And that's all of the systemic costs that this court laid out in Part 2A of Fokker. So in order to have the sort of anodyne proceeding that some of these questions are assuming, this court would have to issue mandamus. You'd have to take off the table evidentiary proceedings and the like. You'd have to take off the table contempt. You'd have to say just the Rule 48 motion, you address that with dispatch, and then you could come back to this court. But at that point, if that's the proceeding, there's
the district court doesn't even have the authority to appoint amicus to advise it on whether it should issue an order to show cause for contempt.
So, Judge Wilkins, we, unlike the petitioner, we have not argued that district court generally lacks the power to appoint amici, I think, either under the rules or more likely under their inherent authority. But what we have said is that the particular amicus here is improper for all the same reasons that appointing amici and going through an elaborate process would be improper in the DPA context under Fokker. And if that's true, then a fortiori it's got to be true for the Rule 48 context, which was the basis for Fokker's reasoning with respect to DPAs. So we're not saying that the district courts don't have the power to do this generally. What we're saying is that here that there are problems with this particular appointment of the amicus. And just to get back to your question, Judge Anderson, I think once we know that those are the harms, there's no reason not to take that final step, because we know the harms that are going to play out. This has already become, and I think is only becoming more of, a public spectacle, particularly in light of the amicus filing in the district court 2 days ago. And it threatens to harm not just the integrity of the executive and its prosecutorial discretion and its deliberative processes, but I think, frankly, it threatens to do harm to the judiciary as well.
Mr. Wall, if I could just ask you, the court has, our court has repeatedly declined to grant mandamus when the government addresses abstract separation of powers violations, such as in al-Nashiri. So I'm just wondering if you can be more specific and more particular about what the concrete separation of powers violation is here. Rule 48 does allow leave of court, right? So is the problem, what precisely is the problem here? What precisely is the infringement on the Article 2 power?
I think, Judge Rao, that the separation of powers harms here, you're right, they can be very subtle and very abstract in a lot of cases. I think they are as stark and as concrete here as they come, because here we know from what's transpired below and from the briefs in this court that what the district court is contemplating is a sort of intrusive, fact-intensive inquiry into what they say are a host of factual questions. Why did particular prosecutors not sign the brief? Why did the Attorney General make this decision? Was he right on these various grounds? What about the uncharged conduct with respect to the Turkey statements? We're going to have to brief and apparently put on evidence in defense of all of that so that the district court can then reach a decision when circuit law.
All right, so let me try this.
But if you stop it here,
getting my own audio back in an echo fashion, which is a nice bonus. If I turn that off. No?
yeah, you get an audio echo.
All right. Deep breath, Kurt. I'm the best YouTube. I'm the best YouTuber this has ever been. Like no one ever was. So if I
you got the echo.
Yeah. Mute screen on. If I turn that off. No. I have no idea how to fix this. If I turn this mic off. Okay. Yeah, if I turn my own mic off, but then I have a delay. So I can't do that. Yeah. I don't know how to fix
Oh, you don't have
this
to.
problem.
You don't have to worry about it. Just let me. I can listen to it from the YouTube feed. That's fine.
The only problem is that it's behind because YouTube takes like 20. So where you're listening and where I'm listening is the same.
The only way I can see, because if you just do everything through StreamYard, but you've already got Discord set up, right? Not Discord, OBS.
Yeah. I could change it.
What you can do is just why don't you just have this? Why don't you just run OBS and then run StreamYard as regular and have OBS just shoot out StreamYard?
Yeah.
So in other words, it doesn't stream out your mic directly from your mic, and it doesn't give you audio directly to your audio. Everything will be coming through StreamYards.
All right, let's give that a shot. Turn that off. And now I have that. That's really weird. Because it's not instant. Because it sounds weird in my head. Ugh. One, two, three, four. Yeah. 1, 2. Hello, everyone. I can't do it. It's off by like 16th of a second. It's distracting.
So don't.
All right. Let's just press on.
As that's exactly what courts shouldn't be doing. It says, quote, no substantial role, end quote. It's hard for me to see a much clearer.
But the court, but all of the 48A opinions from every court has said that the court has some role in that. The role involves making sure that there's not something that's being done clearly contrary to the public interest. So then there must be some case where, or some set of circumstances where, as unfortunate as the clash of the two branches of government might be, where Rule 48A does some work. Isn't that right?
Judge Wilkes, I think it is right in the following sense. 48A does work in cases where it's an opposed motion. And even where it's an unopposed motion, we don't dispute that the court can ascertain that it's got the considered decisions of the parties. You don't have a prosecutor who's been bribed or a defendant who hasn't been counseled about the dismissal. But we do say that for unopposed motions to dismiss, relatively small set of applications under 48A, that where the parties agree and they are both making considered decisions, yes, the court is required to grant in light of the constitutional concerns that this court discussed in Fokker. And the second thing I'd say, Judge Wilkins, just to drive this home is, I understand respondent to accept that everything I just said is right in the pre-plea situation. They agree that if the defendant hadn't pleaded and this was just an ongoing prosecution, we could pull this back. There'd be nothing a court could do about it, couldn't force us to go to trial. And a court, even if it were upset about our motives, couldn't perform any oversight. It would need to grant the motion. And so the move that they make, and it's the key to the merits at page 19 of the reply, is to say, okay, but Fokker is just for the pre-plea situation. It doesn't apply once the court has accepted the plea. And I think that's got to be wrong for no fewer than 4 reasons. First, once we know that it's not the concern of the rule in most of the cases, which are the pre-plea cases, then we know it's not really what the rule cares about. Second, the constitutional concerns are exactly the same after the plea. We no longer want to proceed as the executive, and there's no longer a controversy between the parties. Third, we know, as you said from Rinaldi, the U.S. can dismiss even after judgment, even after trial, let alone after a plea. So there's no magical plea line. And fourth, Fokker rejected exactly this distinction. It said accepting the plea agreement, to be sure, is a judicial act. That calls on the court's authority. But just dismissing, that it said doesn't. That's just letting a case go in deference to the executive's exercise of prosecutorial discretion. And once you know that that plea line, there's nothing magical about that in terms of Rule 48 or the Constitution, then I think their case on the merits collapses, and then we're just back to Judge Henderson's question about the harms and why grant mandamus now.
Yeah, they keep making that argument that Rule 48 doesn't set up a magic line at the plea, which is a reasonable argument, but I don't think is immediately self-apparent, because you could make the counter that, having been accepted by the court, that the executive loses the authority, or loses a lot of the authority. So the idea that 48 doesn't set up a line is interesting. And as I was saying at the start of the stream, we in law want to give each and every word in a law some kind of effect. So with leave of the court presumably means something. It's just not words that we're going to throw away. It's got to mean something. So we can construe it narrowly, I suppose, but it can't just be nothing, right? And we can't hear Nate. Is your mic on, or is it my fault? Okay, hold on. Christ. No. Okay, I muted something. Go ahead, Nate.
Yeah, can you hear me now?
Yeah, I can. Thank you.
That's all right.
Yes, thank you.
Yeah, I'm thinking. It seems like this is more of a formalized procedure in which what's the prosecutor's role at each particular point. And it seems like I think the argument that he's making is a good argument in the sense of you can't force the prosecutors to prosecute a case. That's something you cannot do. But here is some way where the prosecution is actually over. So is the prosecution over at the plea? Is it over, and it's true the government can move to dismiss a case even after everything is guilty, but that would still, the court, you have death row cases, right? Where both the government and the defense attorney comes and says, yeah, this person is innocent. And the court at that point in time still has to review it and still has to, because you have them go up to the Supreme Court all the time, right? So to say that these are automatics, I think is I think it's a bad argument. I think whenever we hear from the other side, I think they're going to make the point that the prosecution is effectively over. The case and controversy piece of it is actually over. He has pleaded guilty. He has accepted liability. Now it's about how much time he gets for that liability.
Yeah.
What controversy do we have?
Yeah, there's at least one slightly contra idea I can think of, which is that failure to disclose some of this stuff from the government in terms of how it set it up would form some kind of Brady violation. And if there is a Brady violation, then presumably you'd be saying, well, let's effectively do a mistrial. And then having done that, then we can just not prosecute the second time around. So there's that idea. But even then, presumably you're having to make some kind of motion that would have to be accepted.
Yeah,
So,
exactly.
So.
But Fokker made clear that there are different considerations at different stages of a criminal case, to the extent that you, even if we credit that Fokker is binding on Rule 48A, in here we have two different district judges that, as a part of their obligations under Rule 11, made factual findings as to materiality and a basis for a plea, etc. And so the government's motion doesn't just implicate the government's position, it implicates those rulings that two district court judges have made. So the case isn't in the same posture as it would be prior to a plea agreement in that respect.
Well, I absolutely agree with part of that, Judge Wilkins.
Yeah, obviously.
It is certainly true that there are different concerns at different stages. And Fokker says accepting the plea agreement does call on the court's authority because it has to ascertain whether there's a factual basis for the plea. But it contrasts that with dismissal. And take a case like, and so the part I disagree with is that once you've crossed that plea line and a defendant has pleaded, that suddenly everything that follows invokes the court's authority in some way that changes the calculus, because Fokker says that's not true. And the best example, I think, is in the United States in the Seventh Circuit. The district court, there wasn't just a plea, there was a sentence. And in light of the sentence, the government wanted to dismiss some of the charges because it no longer wanted to proceed with them. And the district court was upset about that. It wouldn't allow the government to dismiss. And the Seventh Circuit said, look, it doesn't matter, even if the government's trying to get around the district court's sentencing authority. It's the master of its own case. It gets to decide when to bring or when to dismiss charges. So I agree that of Rule 11 acceptance of a plea agreement, if that's what were before the court, that's different. But this, and Fokker's language is crystal clear about this. It says accepting DPAs and dismissing under Rule 48, it says, quote, are not formal judicial action imposing or adopting, end quote, terms on defendants or parties. They're not the court formally signing off on anything. When Judge Sullivan grants this Rule 48 motion, as he's required to, he's not taking back anything he's done before. He's not expressing any opinion on the government's case. He's not saying he agrees or disagrees. He's just acknowledging a co-equal branches exercise of its core executive power.
I have a question about your position, the United States position about its representations in support of a Rule 48A motion. Is it your position that the government does not have to state all of its reasons in support of dismissing the case, only those that it chooses to share with the court?
It is, Judge Wilkins, but I don't think anything turns on that here, and that you need to agree with me on that. I think we could have come in and just moved to dismiss without providing an explanation to the district court. We do that at times, and district courts routinely grant them. No appellate courts ever reversed in a situation like that. But here we did. We went beyond what we thought we were obligated to do under the circumstances. We provided a robust explanation to the district court, and we think whatever Rule 48 might require as a procedural matter, we've more than cleared that hurdle, as Ms. Powell said. I mean, I think this is one of the most robust Rule 48 motions you'll find.
So to, I guess, understand my concern, suppose you have a case where a federal law enforcement officer has pleaded guilty to a criminal civil rights violation for using excessive force. And then the government says that they've uncovered some Brady evidence and are moving to dismiss under 48A after the guilty plea. But part of the reasoning of the authorities was that as to why they didn't believe they'd be able to prove this case beyond a reasonable doubt was that the defendant is black, I'm sorry, the victim is black, the defendant, law enforcement officer, is white, and they did not believe that the jury would believe the black victim over the white officer without corroborating evidence. And that's unfortunate, but that's the reality. And so that was one of their reasons for dismissing. But they thought that that wouldn't play well, so they didn't say that in the motion. They just said that the exculpatory evidence was the reason they're dismissing. Is that proper?
So 2 points, Judge Wilkins. One is legal and one is practical. The legal one is that there's an easy way to deal with that here, given the mandamus posture. I think Fokker is clear that the government, as long as it provides no reason or any reason at all, can and it's not an unconstitutional reason, can dismiss. So yes, I think that motion there should be granted. But the easy way to deal with that in the mandamus posture is to say, look, even if you think that there's room for some kind of a Richards-like rule, or we think there's it's not clear.
We got to talk to the Department of Justice about their phone system. You know, that's apparently it's just cutting out at random intervals, beep beep, and then just dies.
Okay, but can you stop it? I think that was a pretty interesting hypothetical that the judge threw out there.
Yep.
I think that was an interesting hypothetical because he's saying, somebody's asking what is Brady evidence. Brady, there's a case from I believe it's the 1960s. And it's funny because we only call it Brady violations, but Brady's a case in which the prosecutor found evidence
Brady
that
versus Maryland,
the
right?
defendant, yes, the prosecution found evidence that the defendant was innocent, that he could not have done that crime. And the rule at the time in Maryland was that the prosecutor didn't have to turn over, could evaluate and didn't have to turn over that evidence at the time of trial. So Brady was eventually convicted. And so Brady appealed when he found out that the prosecutor actually had the evidence that he was innocent. So in that ruling, the Supreme Court said in Brady that the prosecutor, it established a couple of things, that the prosecutor is to seek justice, not convictions. And that if you have evidence that the standard is that tends to show that the defendant is innocent or is not guilty or helps the defendant's case, a very, very low standard, that will allow the prosecutor has to turn it over. And in most cases now, in most states, I think in all states, if the prosecutor has evidence that is determined to be Brady and has not turned that over, the prosecutor has committed an ethical violation and can be disbarred. Brady is a very, very serious thing to a prosecutor. If you have Brady evidence that you have not turned over, that tends to show that the defendant is innocent, then you can be disbarred. It's called a Brady violation. So that's what we're talking. When we mean Brady, that's what we're talking about. Go ahead.
Yeah, and what was this also interesting about your discussion then is just how we speak in shorthand using these names where there's these long, rich histories, and we consolidate them just into a name, like Miranda. Miranda was a guy. His name was Miranda. Yeah. and he was trying to be arrested by a state called Arizona in a case called Miranda versus Arizona, right? Miranda was a guy, or Heller in DC versus Heller. I've met Heller.
Yeah.
I've met Heller. I know Heller.
Yeah?
Yes, I have met Heller. I've met him. He is a guy. I met McDonald too before he passed away. He was a very shy guy. But I met McDonald from Chicago versus McDonald fame. But he was a very shy guy. Heller Heller definitely doesn't have that problem. But it's just interesting because we talk about these things and we consolidate them into just these bywords. Brady, Miranda, Heller.
There's a question in the chat. It says, has any prosecutor ever been disbarred for Brady? Yes. Look up the Duke LaCrosse case. That prosecutor
that was a total dumpster fire. That kid, the Duke LaCrosse prosecution was a total absolute dumpster fire. Yeah, that was great. It was let's string these guys up basically, and that was just super wonderful, good work. Way to go, prosecutors of Durham, North Carolina. That's just genius work on your part. And then you make everyone look. you're so desperate to make these guys look horrible, and it's
Guilty.
like it all fell apart. It was basically none of it was true. It also like reminded me of the assault case from University of Virginia that got a lot of fame, and where that like completely all fell apart was got in Rolling Stone, about the travesties of this campus assault. And then like, no, none of that actually happened in any way. It was basically completely fabricated. So it's like, way to go, Rolling Stone, way to go, prosecutors in North Carolina. You're just doing genius work here by trying to show stuff that never actually happened. That's great.
But let's not forget, Brady's also is an ethical violation, a constitutional violation. Like, Brady rings all the bells. If you have a Brady violation, you're in serious problem. You have problems all the way around. You don't. That's one of the biggest fears of prosecutor, and that's why prosecutors just turn over everything. When I was a prosecutor, whatever evidence I got to defend it, I turned it all over. And I remember, like some prosecutors like to play that game where there's some evidence we could turn over on the eve of trial. I'm just like, fuck it. Here it all is. I'm not trying to play trial by ambush.
In my very brief stint as an intern in the juvenile prosecutor's office when I was in law school, we had open file. So we'll just literally give you our entire file. We'll just give you the whole file. Like, you want discovery? When can you come by? We'll just give you the whole damn file. So it's like, we didn't do that either. So good times. Not that this was made. Did I ever tell you that? I have some great stories. My first day on the job as a brand new intern in the juvenile prosecutor's office in Akron, Ohio, I was tasked with finding out how to make meth, because we were prosecuting a kid who was running meth lab. This is back in 2007. This is well before Breaking Bad. So he's well ahead of his time in trying to in this juvenile kid running a meth lab. So so it's like, figure out how to make meth, because we want to figure out like the mechanisms that he would use. So basically, I was using government computers to troll the dark places of the internet how to make meth, trying to figure out how he would do it. So that was good times.
Oh my God! No, you trust me. When you're an investigator, there was one time, and I feel bad for even saying this, but there was one time when I was a cop. I had just become an investigator, so I was like maybe 3 months as an investigator, and we had this woman come in, and this was probably one of the most gorgeous women I've ever seen, and so she came in to write a complaint. So I was just in the catch, so it was my turn to write the complaint. So I'm like, yo, yeah, I get to write this complaint. So so I get my professional. So what's the complaint? So she's telling me the complaint, and the complaint was that it was a revenge porn case. So, so I'm writing down, taking all the notes. So she gives me the links and all of the, things where everything is at. So my boss, my boss comes up, he sees her, he, gives his little speech or whatever, and he gets out of there. So he asked me what's going on. So I said, I got a revenge porn case. I'm going to go look at the evidence right now. He's like, hold on. He said, hey, call the LT. He said, we need to see this evidence right now to determine the strength of this case. So
we need to examine it in detail. Lots of detail.
Yes.
Notes.
And it was true. It was true. We had an arrest. We had to go make an arrest, but we had to make sure that evidence was
real.
We
would really make sure. Really make sure.
Yeah.
Really make
sure.
My God.
Oh,
that's
Go ahead.
No, I was just saying that's hilarious though. Yeah.
Yeah. So some people in the chat are saying, well, yes, evidence was withheld in this case. I grant that. But Brady is not any evidence. Brady is certain evidence is Brady and certain evidence is not Brady. So evidence that's and it's
technically
weird,
it's exculpatory and tends to rebut the presumption of the defendant's guilt, I think is the wording, right? Something like that.
Yes.
Yeah.
But the evidence here, I don't think gets to the level of Brady. It shows that something weird happened, but it's not Brady evidence because he lied. So it's like you would have to show in some way Brady evidence would show that he did not lie. That's Brady evidence in this case.
The thing I unfortunately agree that it's not Brady evidence because unfortunately what the FBI did, and I say unfortunately because I really think it's unfortunate, but what they did unfortunately is not entrapment, because entrapment is such a high standard. So they definitely set him up, but they didn't legally entrap him. And unfortunately, the FBI and federal authorities have been known to do this from time to time. As I was saying earlier in the stream, like 18 USC 1001 is like their favorite law of all time. They love it so very, very much because it's basically like their go-to. They use it like the biggest club ever because it's pretty hard to have a conversation and not misrepresent something. Whether that's intentional or not is a whole nother set of problems because, of course, technically, for it to be a lie, it has to be knowing. So you have to actually be, telling a lie as opposed to misremembering. So did Flynn actually lie? I don't know. He had a conversation with the FBI in which he relayed a detail that was incorrect. Did he lie? I don't know. He pled guilty to it because maybe it was easier and they were threatening him and they were threatening his child and a whole bunch of other reasons because way to go, FBI. We're manufacturing criminals. That's good.
But he also told the same lie to, like, all right, I even accept that. But he told the same lie to the VP. Was the vice president threatening his children and you know what I'm saying? Like, this wasn't just a lie. It was told to the FBI, but it was also told to people in the administration. Trump said he fired him because he lied to the VP. So I don't know. Maybe they were threatening his family too. It just, I don't know. There's a lot of moving parts here.
Maybe he was going for plausible deniability, or I'm not going to tell you about it so that you can plausibly deny it. He's trying to protect his boss. I don't know, but yeah, the whole thing.
Maybe and the boss is like, he lied to me. He lied to me.
Oh, the whole thing is dubious, but I have a little bit of a place in my heart where I get a little bit angry at the federal government on this charge because they use it in situations that I feel are not appropriate en masse. And so Flynn is just another example of this to me. Regardless of whatever else he did. Don't talk to the FBI.
I will tell anybody. Never. I don't know why people. No, two things. I don't know why people talk to the police. Yeah. You don't know how many times when I was an investigator, I would say, "Hey, you want to come in and talk to the perp?" And they'd be like, "Yeah, sure, let's come in and talk." And they try to sit there and convince me that they were telling, and I would have the whole thing. And one thing I think a lot of people don't realize is that I'm not asking you questions that I don't know the answer to. I'm asking you questions that I know the answer to because I want to see if you're being honest with me. If you are the person I'm looking for. Because if I'm coming in and trying to get information from you, you can tell me anything. Now, there's two types of there's two types of questioning. There's one where it is a fact finding, where I'm trying to ask you questions and then try to fact find to see if you're telling me is true. But then the second type is, if I'm telling you to come talk to me, that's generally, I already have facts, and I'm trying to see if what you're telling me is going to line up with these facts. And I think that's what happened here with Flynn. They had their facts, and they were like, all right, let's see if he's going to tell us what we already know, and he didn't. Yeah, and that's when you got the violation.
I loved it from Breaking Bad or Better Call Saul when Mike was talking to the guy. It's like, yeah, they're bringing you in for a fishing expedition. They're going to bring you in. They're trying to make you your friend. They're going to bring you comfort, and then they're going to break you. And it's like I read the interrogation manual. I read it as part of law school. They referred to and like how you set this up, and it's like I've seen the interrogations, man. It's like we're gonna set you up. Yeah, rapport building. We're gonna expose you, and then you have the moment of truth where the person has broken, because then they start to do this. When they bend over and they start to cover their face, it's like, yep, it's over. It's all over.
Listen, I'm a Dolphin fan. I'm a huge Miami Dolphins fan. I hate the Patriots. But if I have a perp that's a Patriot fan, when I walk into that room, I got a Patriots jacket on, maybe a Patriots hat, and I'm talking about how Tom Brady is the best quarterback on the planet. Why? Because I'm building my rapport with you.
Yeah.
It's going to be easier for you to talk to me. I'm not going to, are you hungry? You don't know how many perps I've bought sodas for. You get more, people forget this. You get more for $20 talking to a perp than you get if you want to beat them up and send them in the streets. Take a $20 bill to the projects and you'll get all the information you need to know. Trust me.
And that is it's also in line with military. Not that I'm an expert on the issue, but what I've read in terms of even like military interrogations, POW treatment, like you get a lot more by just becoming their friend, and and they'll warm up to you and they'll just tell you all kinds of stuff rather than beating and stuff like that. So yeah, it goes a long way. Yeah. But you're actually my friend, Nate, right? You're not trying to exploit me for something in the future, right?
No, not now. Damn it. Maybe if I get back in law enforcement, maybe I will.
How deep does this undercover operation go, Nate?
I've now pretended to be a lawyer. No, it's funny. I've gotten, and people think, you hear everybody say that they'll never confess to crimes that they didn't commit.
Oh, yes,
I've
you
gotten
will.
3 people to confess to crimes that they did not commit, that I knew afterwards they did not commit. I've had to go back and undo stuff, undo arrest, because these people were so desperate to just tell me what they thought I wanted to hear, that it was like, okay, yeah, I did it. Oh yeah, no problem. You're under arrest. Let's go. And next thing you know, you're like, why did you admit to it? Oh, because you were so nice and I wanted to go home. And really?
Is there anything you'd like me to confess to, Nate, to make your life easier? What can I confess to make everyone's life easier?
Yeah,
I stole the Lindbergh baby. Yeah,
give me your PIN number, your bank account codes, and then we'll talk after that.
Yeah. So the operative lesson here from 2 attorneys, as always, is please don't talk to the police. If they say you have a right to remain silent, that is your clue. You should probably do that, and you should probably ask for an attorney, because nothing is going to go well. And it's like, well, if you get an attorney, we won't be able to help you anymore. Okay, well, I don't really want your help that much, but thanks, for that little note from the police. We won't be able to help you once the attorney gets involved. It's like, well, that's great. Let's see if the attorney wants to help me for several $100s an hour. Let's go back to this audio.
Oh, yeah. An indisputable.
I'm sorry, I couldn't hear about 10 seconds of that. Could you repeat whatever you said?
Sure, I'm sorry, Judge Wilkins. If you thought that it wasn't clear under Fokker whether the court could allow that type of explanation, you could try to leave that open and just say, look, whatever that might be on the merits, it's clear and indisputable that wherever the bar is, the government met it here through its fairly fulsome explanation. And the practical thing I'd say is, I certainly hope that the government hasn't ever filed a motion like that, and I'm not aware of it. But even then, yes, I think the court should have to grant it, because the government, whatever its motive, no longer wants to proceed. But what you would see is you'd see other defendants walking in, attaching that motion, and bringing Armstrong claims, saying the government is making racially based decisions in its prosecutions. And based on your hypo, it sounds like they.
So yeah, racially based prosecutions. Haven't heard that idea for a long time, but yeah, the idea. I did cover a case like that on my channel where it came up. I think it was New York City, as memory serves, where the New York City, I believe it was the Second Circuit Court of Appeals, was actually overturning. They weren't overturning. They were requiring the government to turn over certain internal documents relating to law enforcement that you wouldn't normally do because of these claims, because apparently the police in New York City were setting up specifically based on race, and there was enough information, so the court was actually saying you actually have to disclose like internal stuff on your police practices you wouldn't normally get to. So yeah, bring an Armstrong claim for racial-based policing. You're not supposed to do racial-based policing. We can debate how well that's been going.
Oh yeah. I'm interested in this. It is back and forth with the judge, though. It's fascinating to see, because I'm trying to figure out. I understand this. Who is this arguing for the government? This is because I know the first person was the woman. I'm assuming she's from the Justice Department, and this person's from where? The person's arguing now.
No, I think the first one was Mr. Flynn's attorney. I think that was Mr. Flynn's attorney.
And this is the Justice Department representative. Okay.
Yeah, I think so.
You'd have pretty good grounds for that. So I think there are remedies for this other than needing to contort Rule 48 to get into what the executive's motives are.
If there's remedies for it, there can't be a remedy for it unless you know that it's happening. And if the government doesn't have to disclose all of its reasons, then you never know that it's happening, right?
But that's always.
And if the district court isn't allowed to ask whether there were any other reasons, you'd never know that it's happening, right?
But that would be equally true in a case like Fokker, Judge Wilkins. I mean, the district court could always say, look, I think that the U.S. attorney has cut a sweetheart deal with the corporate defendants here. And so I want to get some briefing and I want some argument and hearing on whether there was improper influence brought to bear on this. And the point of Fokker is that it isn't to the courts to police whether the executive has pure or impure motives. The remedies for those occur in political and public arenas.
Is this guy a lawyer because he's just dismissing the procedural posture?
Yeah, I think he is to some degree dismissing the procedural posture, but I think he's also making a fair point about, I mean, because it gets into whether or not, the moment of him being convicted because the plea has been accepted, which is a conviction. By pleading guilty, this is the same as if you would, we're convicted as jury. Do you understand that? Yes. Okay. So you've been convicted. So yeah, you could differentiate or you could not. And so he's maybe trying to say, well, there's no differentiation here, that it's the same all the way through, which I think is a point of contention.
Yeah.
But yeah, I think it's a little bit, they're trying to make an argument in the negative that doesn't quite work. Like if they're making sweetheart deals for you for improper reasons, that's a bit of a challenge. If they're coming after you for improper reasons, that might be a due process problem. Right, there might be a substantive or procedural due process problem if they're coming after you for some sort of animus that wouldn't normally apply just because you're a criminal. So that might be an issue. So to the extent the FBI was specifically targeting Flynn in the first place because of an improper reason, which might again be a reason to dismiss based on your, depending on your viewpoint, because they were doing this because he was an ally to Trump, for example, maybe, then you have an argument. But if they're giving someone a sweetheart deal, it's like, what is the due process is they gave someone a break that they shouldn't give someone else. It's like, I don't know how that works. So that's a bit of a logical problem.
Yeah, the branch's dismissal of corrupt executive officials, even impeachment if it comes to it. But Rule 48, Fokker says, is not the mechanism for policing the kind of harms that you're worried about. And if a court could do the sort of thing you're talking about, then I think Fokker has to be a dead letter, because either with respect to Rule 48 or a DPA, a court concerned about the executive's motives could always inquire, and I understand that inquiry to be exactly what Fokker shuts off.
So, Mr. Wall, are you suggesting, normally the standard is that there is a presumption of regularity. What about the case in which a district court feels that presumption is overcome on the face of the materials presented by the government?
So 2 points, Judge Rao. First, I don't think that presumption is relevant here, and put it to you this way. If a district court thought that the government had a bad faith motive for declining to bring a prosecution, I take it everyone agrees that the court couldn't force the U.S. to bring the case. And the same is true for maintaining a prosecution. As Fokker said,
Correct.
There's no oversight role for the courts. And when it refers, this is the key thing, Judge Rao, when it refers to the presumption of regularity, it's not saying there's some exception to the rule it's laying down in that situation. If you look at that passage of the opinion, all it's doing is listing that as another reason for adopting its rule. Is that even with respect to constitutional claims, the courts are very loath to second guess in the absence of clear evidence of unconstitutional motive. And so it gives that as a reason.
Yeah, so that's 100% true. The courts are extremely loath to do a constitutional issue if they can't. We have whole doctrines dealing with constitutional avoidance and trying to avoid constitutional issues, and we try to interpret things in constitutional ways whenever possible. So the idea of looking behind the curtain as a court is just something we don't do. So we're going to assume that things are as they appear to be. And we're not going to assume the government has an improper motive unless you come up with quite a bit of evidence, which is why that Second Circuit case I referred to earlier was so notable, because it's, it goes against the normal rule. Now, I thought there was enough evidence. I thought it was the right decision in that case. But what they're saying makes sense. Like, we're not going to assume that an improper animus or improper motive or something unless you come up with a lot more. So, good luck with that, I guess.
No, you're right. I think you're right. I'm now, honestly, I'm tired of this guy. I want to hear the other side. So I want to see how he ends this, because this is actually pretty fascinating.
It is pretty fascinating, yeah. I think the arguments that we've heard so far are pretty good. So yeah, how would we summarize this guy's arguments in 30 seconds? We came up with a woman. The judge is creating the 30 second for the woman is the judge is creating issues that didn't exist. He's manufacturing issues, and so it's improper to have an amicus for issues that aren't being raised. And also, there's a jurisdictional issue. So that's her argument. What's his argument in summary? He's a little bit harder to summarize.
His argument is twofold.
Discretion is good.
Well, number one, I think his argument is procedural posture doesn't matter. So no matter where you're at within the litigation, within the criminal prosecution, if you're at the before and the person is being arrested, or even after conviction, he said after conviction and sentencing, if a Rule 48 motion was to come up, and both the government and the defendant said we want the case to be dismissed, no matter where it happened on that spectrum, the court has to grant it. That's what it seems like his argument is right now, and I think that argument fails because it fails to realize that yes, the discretion that he's imposing for the prosecution is strongest during the prosecution. Again, and he even mentioned, he said, I can't force the government to prosecute somebody. But I think it does get weaker during sentencing. But first, I want to hear the other side of the argument. But I think his argument is good, and I think it really plays well with the first argument that the court didn't actually have this power to do it.
All right, so maybe we'll skip ahead and see if we can find out where the next person talks. So we'll skip ahead a little bit.
Rule terrible consequences as I do, because there's nothing like that here.
Or other pressures from the public and the media.
Asking the defendant, are you sure about this? Because it sure seems like the government keeps yanking your chain.
So why isn't it the case that if the government makes a considered but racist decision, that it...
Let me say two more things, Judge Wilkins. First, I think as Judge
I wanted to hear that. That was
then you can inquire in every case.
You said you were tired of the guy. I'm trying to figure out where the next guy starts talking.
I think Aiken is right in constitutional
That's true
order.
too.
And Mandamus is a drastic
unconstitutionality. There's any evidence that we violated the Equal Protection Clause or anything like that.
Thank you.
Mr. Wall, let me ask you, you threw out a question probably 30 minutes ago. What would be the harm in going ahead granted?
So, Judge Henderson, a few points. Yes, it's a deliberative process. It chills law enforcement. It sets up a conflict between of these. We are here saying there are serious, indeed grave, are not filing a mandamus petition to be taken as legally relevant.
Wouldn't that require the court to
and the Supreme Court grants mandamus? This case, it seems to me, is two steps beyond that. You have actual conflict between the branches where the court wants to inquire into why we did this in the face of allegations that there was some
We can see your search.
I understand that to be exactly what Chief Judge Srinivasan said in Fokker courts may not do. And I really don't think it's hard to see what the harms are going to be to the government over the next couple of months if we and the defendant are put through that process, which is all for naught, if at the end of the day the district court is required by law to grant our motion.
Well, let's drop the phrase regular order and let's talk about one of the requirements I don't think I've heard anybody mention, and that is the adequate remedy at law. That's what I'm talking about as far as regular order. You granted, assuming you have an indisputable right, and that to me seems pretty clear. You still
like
have to say why
so it was close.
There is no...
I was skipping. I went to C-SPAN to figure out where the timestamp was, so I could skip to the right part of the YouTube video. That's why I was searching.
Court. The issue here is whether a federal district court judge.
It's funny because I think we have his arguments.
Yeah. So I had to go to C-SPAN to find the right timestamp because C-SPAN has a timestamp, so I had to figure out where to skip to. So I wanted to skip to 113. It looks like is where the next person takes over, at least on C-SPAN's timestamp.
Second, the law does not clearly and indisputably foreclose the district court's prevent this district court from even considering
foreclosed by Fokker. That would be more harmful than what we're facing on the circumstances here. If ever the court were going to say a district court needs to grant the Rule 48 motion, that's what Fokker clearly and indisputably requires. It seems like this would be the classic case.
Right. So that's the end of his argument.
Are there any more questions?
No.
But obviously he
not,
wants to
we'll
now.
Hear from...
Now, can I?
You may. Yes.
What you're going to see now, what you're gonna, what the audience is going to see now, is that when you're arguing, hold on. Sorry, I gotta mute myself because I keep hearing myself talk, like 5 seconds after, because I'm listening through the YouTube thing.
Yeah, it was even worse when I was trying to get the rebroadcast thing working, because it was rebroadcasting in my own ear with like a 16th second of delay.
Oh, that's horrible.
And that's like, I couldn't deal with that.
No, what I do for all you want to be lawyers out there, what you're going to see, and what I should have mentioned before, is that you're going to see both sides probably address Fokker, and there's a nice little technique that's being used by both sides, for the Trump team and for the petitioners. They are using what they call analogize. They want to say Fokker is the case on point. It's, and they're saying all of our facts are Fokker. You should rule just like Fokker did. So it's analogizing the case. It's saying Fokker is the case. We love Fokker. We are just like Fokker. So now you're going to hear the other side distinguish. They're going to say, this is not like Fokker, and these are the reasons why. And the court's going to say, well, isn't it like Fokker? Why isn't it like Fokker? So that's what the crux of this argument is going to come down to. One side is saying Fokker's the point. You need to do what Fokker says, and this side is going to say Fokker's not on point. This is the reason why you don't need to do it. It's a common legal tactic. It's called analogizing and distinguishing between cases, and you'll see it. You're going to see it play out right now.
Yeah, absolutely. All right, so let's listen to this next person.
Ms. Wilkinson.
Mm-hmm. Ms. Wilkinson.
Thank you, Mr. Wall.
Thank you, Judge Henderson, and may it please the court. The petition asks this court to grant really an extraordinary remedy for Mandamus to prevent this district court from even considering or questioning a pending motion. This court should deny that petition for 3 reasons. First, the government's motion, as this court has already pointed out, is still pending, and it may very well be granted. Alternative relief is available below. Second, the law does not clearly and indisputably foreclose the district court's consideration of the government's motion. And third, it would be inappropriate to grant mandamus in a case involving open questions where the government is raising novel constitutional arguments that were not raised below. As this court has said, it is essential for those questions to be raised below to maintain the regular order. No one disputes that a federal district court cannot second-guess a legitimate exercise of prosecutorial discretion simply because it disagrees with it. But that is not the issue before the court. The issue here is whether a federal district court judge can set an expedited briefing schedule and appoint an amicus to provide adversarial briefing before ruling on a motion that requires leave of court. The answer is and must be yes. Judge DeFoe, yes, Judge Rowe.
Ms. Wilkinson, yes. So, but I mean, in a case such as this, where both the government and the defendant agree with the motion to dismiss, I mean, isn't the appointment of an amicus creating an Article III case or controversy where there isn't one?
No, Your Honor, there is a case in controversy here for several reasons. One, as you know, the government and the defendant are asking for the motion to be dismissed with prejudice. By definition, there cannot be a ruling to dismiss those charges with prejudice if the court doesn't have jurisdiction. And the parties want that, of course, because they don't want another prosecutor to come back and then look at these charges and bring those charges against Mr. Flynn. So everyone in this case agrees that this motion, if it should be granted, should be granted with prejudice. So these.
So take a little pause. What really caught your ear there, Nate?
They are asking for with prejudice.
Yeah, in fact, well, yeah, because it would be double jeopardy then, wouldn't it? Of course.
Yes, and so they have a case in controversy. That's the reason why they're asking for prejudice, not to be brought back. So that is probably the nail in the coffin of the case in controversy standard. You still have a case in controversy, because if they would have asked for it to be dismissed without prejudice, then you'd have a better argument for not having a case in controversy.
So you think that because they're asking for dismissal with prejudice, that creates a greater case of controversy?
I think because what you're asking the court to do is forbid all other, nobody else can now bring this case afterwards, even whatever any evidence or so forth. So I think to say that there's no case in controversy, but then asking for the court to foreclose on the proceedings forever, does give the court some limit, because now the court, you're asking the court, you're not asking the court to just dismiss the case like it never happened. You're asking the court to issue an order dismissing the case so it can never be brought up again. So there's a different, my understanding is, if you're asking for it just to be dismissed without prejudice, that is a different remedy than asking for it to be dismissed with prejudice, because the with prejudice now forecloses all further prosecutions in the future. This is where you get your case in controversy. Your case in controversy is now between the court and the future government's ability to re-prosecute this case versus now the defendant's right to have it done.
Right, but because this is a criminal case, I'm not sure that dismissal without prejudice is possible. I mean, you can only do dismissal without prejudice in a criminal case for manifest necessity. Judge dies, jury hangs, something like that.
Mm-hmm.
So I would think at this point, dismissal would have to be with prejudice. He's obviously been put in jeopardy. We've gone far enough along in the process, I would think. So I'm not sure
you sworn the jury.
Yeah, I'm not sure if we ever sworn a jury or not, but we've gotten pretty far along in the process.
This is whether jeopardy attaches. But the swearing of the jury and all that stuff is already done. He's already said he's guilty. He's already pleaded guilty, and that guilty plea has been accepted. So you're past the jeopardy part. Jeopardy is definitely attached. Mm-hmm. So if we're talking about double jeopardy, possibly. But if you're asking for that dismissal, if the defendant is asking for a dismissal and the prosecutor is asking for a dismissal, is jeopardy attached? I would say now that's a question. Is jeopardy attached or versus we're dismissing with prejudice? Those are two different issues. I would say it seems to me jeopardy is attached, but I have to look at this, because if they're both asking for dismissal, it's not a dismissal with prejudice. This would be jeopardy. This would just be double jeopardy. You couldn't try him twice for the same crime.
Right.
Interesting.
Yeah.
But I go ahead. But continue on with the tape.
Okay, cool.
The charges are ended.
Well, what happens, though, in a case, maybe another way of asking this, if the district court were to determine that the motion to dismiss should be denied, then what happens? Then we go on to sentencing Mr. Flynn, even though the executive is no longer pressing its prosecution.
There's no reason at this point to fear that the district court is going to deny the government's motion to dismiss. But if for some reason the facts or the answers to the questions at the hearing gave some basis for that, I'm sure the parties, including the government this time, and Mr. Flynn, would file another motion or another writ for Mandamus. And that happened in Ray Aikens, as you know, and there the court said and denied the first motion or the writ because they said the government hadn't had the chance to act. And in fact, they gave years to the government agency, the NRC, to make that decision. And only when that agency announced that it would not rule did this court issue a writ of mandamus. So here we're not in any situation similar to that. As Judge Henderson has said,
hold on.
The court...
Sure.
Let me stop this. It seems like both sides are arguing a constitutional deprivation. One is arguing there's no case in controversy, but this side is actually arguing that the petitioners are asking for an advisory opinion, more or less, right? The court below hasn't done anything yet, and now they're coming up and saying, well, we presumptively believe we're going to lose, so now we want you to force the court to grant this motion. And now they're saying, well, but that's that would be an advisory opinion. We haven't even ruled on the motion. So you're jumping the gun in this situation. It's like, you know what I mean?
It's possible.
You haven't even let me go through the facts.
Yeah, I mean, it's certainly possible, but you wouldn't do a writ of mandamus after the fact. You'd just be on a normal appeal from whatever decision the judge would render, assuming it was adverse. So if the judge does whatever he's going to do and it's adverse, then you're just on a normal appeal. The whole idea of the writ of mandamus is what the judge is doing is outside of his power and discretion in the first place. So we want an order from you because the judge is doing something that he doesn't have the authority to do, and we want you to order him to stop doing that. because it creates, and there is actual prejudice. It creates time and money and stuff that we have to respond to, and uncertainty and all stuff. So I think there's enough damages, even if we can get to the end of the day, that writ mandamus is proper. Now, writ mandamus is a very extraordinary remedy, but then again, this case is bizarro world, and so we're in some sort of extraordinary whatever, trying to figure out this dumpster fire. So yeah, this is all kinds of weird stuff. Yeah, the DC, because you also have to think about the Court of Appeals that this is, the DC Court of Appeals, or Court of Appeals for the District of Columbia Circuit, to be more proper.
DC,
yeah, it's considered the second most important court in the United States after the Supreme Court.
Of course, it is.
And they look to those decisions pretty seriously, and I think that they are on the whole a little bit more conservative in trying to not put their toes out. I'm not sure exactly which way that goes, though. Are they not? Is it the more conservative? Is it the more restrained conservative decision to let this go forward or not? I don't know. That's from a what's more restraining for the DC Court of Appeals to do.
Well, I think the best thing is not to issue if you're talking about judicial restraint, it would be, okay, we're going to deny the writ of mandamus. You're going to go down, you'll have the facts, we have a fact finding, and then if you lose, then you can appeal, and in that appeal, you can also ask for a writ of mandamus. And then if we send it back, we will reverse and send back with the writ, ordering the court to enter a judgment. And they do that all the time.
I mean, presumably the next thing we would be doing would be appealing our presumable criminal sentence that had just been imposed. Would be the next time we would be before this court, right?
No. You would just do an interlocutory appeal of the motion that was denied. You sent a motion in, the judge denied it. You would interlocutory appeal that, asking for it to be reversed and for the writ of mandamus to order to be done. No.
I understand what you're saying, but in some ways it just feels like, delaying the inevitable.
Why do it twice?
Yeah, why?
No, because the court can rule in your favor. The court can rule in his favor. The court can say, yeah, all right, we're gonna dismiss the case.
That doesn't seem like the most likely outcome, and maybe we save ourselves some time.
Yeah, because right now, essentially what you're doing is you're taking the power from the lower court to even do any, and that's what this is about. Does the court have the ability to inquire about this? That's really what we're talking about. And one side is saying no, and the other side is saying yes.
Yeah, very good. All right, so we still got another half hour of this, so let's listen some more.
Let's try to get through it. Yeah, I'm going to just take notes instead of stopping it.
And has a hearing for July 16th. The order to the amicus is circumscribed as only presenting arguments in opposition, and there's no suggestion that the court is going to call witnesses or do anything that the parade of horribles that the government and petitioner was laying out for you. All this court is doing is getting advice.
And what standard is an Article 3 judge supposed to apply in this context?
Well, in
order to assess the motion to dismiss, Rule 48 just says there must be leave of court. So what's the standard that the district court judge must apply?
Please tell me the answer.
Well, the governing law here is in Amadown, which is still good law, was cited by Fokker. And there, as Fokker reiterated, I think we have to look at whether the presumption of regularity or there was a clear violation of the public interest for the court to seriously consider whether it can deny the motion to dismiss. So there is a presumption, as you mentioned earlier, and the question is there any basis to overcome that presumption? And that would guide the court's inquiry after receiving the briefing and asking questions of the government and the parties.
But the public interest is not a standard that's mentioned in the rule. And in our constitutional system of government, isn't the public interest with respect to whether a prosecution goes forward, isn't that public interest one that is committed firmly under Article 2 to the executive branch and to the politically accountable executive branch, not to an Article 3 court?
Generally, yes, Your Honor. The prosecutorial prerogatives protect and consider the public interest. But in Rinaldi, the Supreme Court specifically held out that standard, I think you know, in footnote 15, where they said they aren't ruling, they are allowing the motion to dismiss be reviewed at the abuse of discretion, and they found that it did abuse discretion, but they said we have not decided whether you could consider a Rule 48 in light of the public interest. And in fact, the dissent, led by Justice Rehnquist, said he thought it was clearly an independent basis to review a Rule 48 motion. But in any event, that law is not clear here. There's no clear and indisputable standard for this court to issue a writ of mandamus based on the fact that the standard is unclear as to how you determine leave of court and any kind of abuse of discretion or discretion. What we do know is in this court, in this circuit court, in Fokker and Amdown, both provided for a review by the court of the government's motion and allowed for questioning. When you decided the case in Fokker, Judge Leon questioned the parties, including the government, in open court on several occasions, and he had conferences. When Fokker was decided, no one stated in that opinion, you cannot ask questions, you cannot have a hearing, and in fact, the government never took Judge Leon up on a mandamus. There's no situation in Amdown.
The government argues that Fokker necessarily rebuked that approach by the district court. What's your response to that?
That's not what Fokker says. What Fokker says is that the district court judge abused his discretion when he denied the motion, which was the speedy trial motion necessary for the deferred prosecution agreement, when he stated that he disagreed with the government's prosecutorial decisions. That indeed is an improper basis to deny a motion to dismiss. And that was the circumscribed ruling of Fokker. Fokker does not deal with Rule 48, as you've talked about, but it certainly doesn't say that you can't have consideration or scrutiny. In fact, it says just the opposite. Throughout the opinion, they talk about the scrutiny and they talk about it being circumscribed, but they certainly don't say the court has no right to ask questions. And here, all the judge is doing is receiving briefing and having a hearing. And the parties, the petitioner and the government, didn't object to that below. Well, they have no alternative. Yes, Your Honor.
I mean, how does the presumption of regularity then apply in a situation like this? I mean, before asking questions, appointing amicus, doesn't the district court have to determine that the presumption is overcome?
No, Your Honor. The court could not determine whether the presumption had been overcome without at least questioning the government about its motion. I think Judge Wilkins was pointing that out when he was saying if you had a pleading and the government didn't include all the facts because they only wanted to present certain facts, the court, by definition, would have to inquire to determine whether that presumption was overcome. The court was clear that there is a presumption, so it is a long hill to climb to overcome that presumption. But there's nothing in Fokker that says you may not question the government. And in fact, the government answers these kinds of questions all the time. If you look at Rinaldi, then Chief Judge King of the Southern District of Florida's court called the prosecutors in and asked questions. The Supreme Court in Rinaldi didn't say that kind of questioning was improper. That happens every day in district courts when a party files a motion and a judge asks questions. That's all that's happening here. There's nothing more, nothing less.
Oh, I mean, there is more here. There's an appointment of an amicus to oppose the motion to dismiss. I mean, that I don't believe is an everyday occurrence.
You're absolutely right, Your Honor, because normally parties are opposed, but here in this unusual circumstance where both parties agree, all the district court did was appoint an amicus to present arguments in opposition to the government's motion to dismiss. And we know, because at least some time has passed, that the amicus filed that brief and did not ask for any witnesses, did not request any fact-finding. So to go to Judge Henderson's point about the regular order, if this court doesn't step into the fray and allows the district court to do its job, it may well be that the court reads both sides, both briefings, asks the government's question, and grants the motion to dismiss.
But who is the amicus representing here? I mean, what is the, I mean, you know, where the government decided to drop a prosecution and the defendant agrees, like, what is the standard that they're arguing? I mean, who are they arguing on behalf of?
They're arguing on behalf of the adversarial position, just like this court does often, or the Supreme Court does. I mean, one of the most famous cases is Dickerson, where the government was not going to challenge the Miranda standard, and the court appointed an amicus there to argue because the government chose not to take that position.
Right, but so what is the, so you're saying that there's some kind of judicial right or judicial power here that the amicus is representing?
No, I think as Mr. Wall stated, there's an inherent power, and it occurs at the district court level, not frequently, for the court to appoint an amicus when it needs advice or legal briefing on an issue. But here, it's even more important because you need adversarial briefing. The government and Mr. Flynn are aligned.
But I don't know, but that's in a criminal case, that is the adversarial process. It's the government against a criminal defendant. What does it even mean to have an adversary where the government and the defendant agree? Like, what is that? I mean, is it representing some kind of inherent authority of the court?
It's representing the authority of the court to understand the opposing arguments. Just like here, Your Honor, you have the government and the petitioner aligned, and the district court was brought in to argue the other side. It doesn't mean that the district court thinks this motion under Rule 48 should be denied. All we're doing coming forward is arguing the other side. And all the district court was doing is appointing an amicus to say, what is the scope of the authority? Can an unopposed motion under Rule 48 be denied? And if so, what is the standard, as you've just asked me? The standard is not clear. So what are the outlines? What are the cases? And what do they say about the court's authority to ask questions and to make that decision?
So then the amicus isn't an adversary. You're saying the amicus is to just provide understanding about the law to the district court?
I think the amicus is an adversary in the sense that he was directed to take positions opposing the government's motion to dismiss. So I believe the government and the petitioner would surely see the amicus as an adversary. And that's important because the court doesn't have to listen to the amicus. As Judge Henderson said, the court is an experienced judge. He can ignore the amicus. He can take some of the points under consideration, and then he can ask his questions and make his ruling. But he wanted to hear, yes, Judge.
Sorry, I mean, I guess I think here, I mean, as you've also recognized, right, I mean, there is a core Article 2 power over prosecution. Even the weakest understandings of Article 2 admit that the executive power, includes control over prosecutions. But it's hard. Absolutely. I think you have to articulate here what is the countervailing Article 3 issue at stake. So, for instance, in the Nixon case, right, there was a conflict between Article 2 and Article 3, and the Article 3 power there that the court articulated was the district court's essential function in protecting individual liberty in a criminal trial. But here, I think, I guess I'm wondering if you can articulate what is the countervailing Article 3 power at stake in a case where the government and the defendant agree on the motion to dismiss.
Fokker laid that out by saying the court is allowed to question the presumption of regularity of the prosecutorial decision even when the defendant and the government agree. Amidon says the same thing. And even in Nixon, Your Honor, the court, citing the framers, made clear that even though you're dividing and allocating the sovereign powers among three co-equal branches, the framers of the Constitution sought to provide comprehensive system, but the separate powers were not intended to operate with absolute independence. And here you've had the government exercising its Article 2 powers, coming in and asking the court to make an independent finding for a plea. It had the court make a legal finding and a factual finding, and as Fokker says, the court has exercised its coercive power and convicted the defendant. There's a public conviction in lieu of a trial, so the government didn't have to go through that. And that's very important for Article III power, that you're stepping into the shoes of the jury and saying, based on this finding, we can adjudicate this defendant guilty. And now the government is coming back and saying, we want you to dismiss those charges and apparently vacate your findings of guilt. It's not clear what they want to do about the actual plea, because that's not subject of this mandamus. The plea agreement that is between the government and the defendant, and what the effect of that is if the charges are dismissed. But they're asking the court, the executive branch, to come in and reverse or vacate its findings. And so the court has the right, the duty, and the language under leave of court to ask the government questions. The Rule 48 language that's been in the statute for over 80 years that the Supreme Court suggested and Congress approved, there's not a case since that language went in that says leave of court is meaningless when the parties agree. And that's the government and the petitioner's position. Be clear, they are saying those words mean nothing when the defendant and the government agree. And that makes no sense under all of the cases, starting with Rinaldi. It makes no sense in light of all the cases around the country, where every panel has at least considered whether the court below abused its discretion when they denied a motion to dismiss.
That's she's straw manning the argument, but
yes, yeah, definitely straw manning a little bit. Yeah, there's some problems. There are some problems here in the argument, but I do like this one judge. I like her. I like her questions. Like, who is this amicus representing? I like that question. Let's just like that series. Like, who is this person representing? The court? Who is this? You know, who is this? It's really, because normally you just can't really have an amicus in the blind. You know, they're an amicus on behalf of someone. So it's like, who are they amicing on behalf of? The court itself, I guess. It's weird position. The whole thing is weird. Everything about this case is weird. I have no idea what's happening. We have 15 more minutes of this. I don't understand why this oral argument is going on forever. I do not understand this. Why is this oral argument so long? Why is it not just a half hour? Why is it an hour 47? Don't know the answer to these questions. Let's press on.
Not be, a kind of rubber stamp, but leave of court is, those words on its own are also, it's hard, I think, to fit into leave of court the ability for a court to keep sentencing a person where the executive branch wants to drop the prosecution. I mean, leave of court may not mean that much, even if it means something more than a rubber stamp.
True, Your Honor, and I think every case has said that it's a circumscribed review, a limited inquiry that a court can do under that standard, but it doesn't say no review. It doesn't say no questions. And the government's position is somehow by the court asking the government questions about the motion that it filed, that somehow that's some irreparable harm. If it is, that goes on in a district court every day of the week. It went on in Fokker, it went on in Amadown, it went on in Rinaldi. The district court in each of those cases asked the prosecutors questions, and they didn't stand up and say, we don't have to answer them. Leave of court means nothing. They answered the questions. They gave the court the information, and the government certainly knows how to refuse to answer or refuse to provide information if it thinks it's appropriate. And this is the reason why this case, all of these issues should have been brought up with the district court below. If the government did not like the process of the amicus or the briefing, or the petitioner didn't, they should have raised it with Judge Sullivan. And instead, they've end run the district court and come to you.
Counsel, the government says that with respect to kind of the case or controversy and the Article 2 prerogatives and how Rule 48A is supposed to work, that even if the government in a motion says, we're moving to dismiss because we don't want to prosecute this white defendant for beating and using excessive force against a black victim, that the court would still be compelled under Rule 48A to grant the motion to dismiss, and that the remedy, if any, for that sort of unconstitutional bias would be, defendants in other cases filing some sort of Armstrong motion, or I guess some, action by other branches, after the dismissal to reprimand the executive. What's your response to that point of view of Rule 48A?
It won't surprise the court that I strongly disagree with that. The case law that's already well known by this court, starting with Rinaldi, and the cases around the country, give examples of where a court can deny a motion, which include bribery. That's not even a constitutional violation. You just heard Mr. Wall mention it a few minutes ago. And all of those cases provide that could be an example where a prosecutor was bribed, and likely, if that were true, he's not going to put that in the pleading in the motion to dismiss, and that could cause a court concern and could be the basis for a motion to dismiss. So if the government was acting in a racist way and either gave those bases to the court, or the court was able to uncover them through questioning, yes, that would be a basis to dismiss. The next question is, then what could the court do? It would depend on the posture of the case. If it was an early decision in the case and the defendant actually hadn't pled guilty, then there's more limited options. But as you said, there's still public pressure that can come as a result of the courts issuing that motion. But if the defendant had pled guilty, the more difficult question, or the more interesting question, is the Article 3 court now has supervisory power over that defendant. As Fokker says, once you have a guilty plea, the court has jurisdiction over sentencing. So the question is, if that police officer had pled guilty and the government disagrees with the moving to the dismissal and the court denies it, could the court sentence that defendant? I don't know the answer to that question, but there's certainly a basis for the judge to deny the motion to dismiss on those grounds.
Thank you.
The district court is not acting as a prosecutor, Your Honor, nor has he made up his mind about the pending issues. He is considering the government's motion and receiving briefing from all the parties. After hearing the arguments, Judge Sullivan will do what he is called on to do on a daily basis. He'll decide the motion. With such a combined inquiry, there is no clear and indisputable justification for this court to enter the fray now and stop a federal district court judge from carrying out his Article 3 responsibilities. Thank you.
All right, any more questions? All right, Madam Clerk, neither counsel has any time left, right?
Correct.
All right, Ms. Powell, why don't you take 2 minutes?
Your Honor, first, there were no valid Rule 11 proceedings in this case to take the guilty plea. But mainly, the first judge who took it should have recused already. He mysteriously recused a few days later, but for the same reasons that would have existed when he recused 7 days later, he should have recused immediately, and the government knew that information, but General Flynn didn't. The second guilty plea colloquy that Judge Sullivan did was not a full colloquy at all. In fact, he ended it by asking repeated questions, saying he had many, many, many questions, including about how this was material and how it impeded the government's investigation. All of that is now refuted completely by the extraordinary exculpatory evidence that Mr. Jensen disclosed that has been hidden from the defendant for 3 years. That's what makes this case different from every other case. When that happened in Stevens, Judge Sullivan had no problem dismissing the case at all. He didn't inquire behind the government's 2-page motion to dismiss. They simply produced the evidence and dismissed the case. Why we're making a special exception here for General Flynn is beyond my capacity to understand the law, when every case in the country has affirmed a grant of a motion to dismiss and not denied one in any way, shape, or form. I mean, every appellate case in the country has affirmed the grant of a motion to dismiss or has said the case has to be dismissed. They don't have any ability to go question behind the government's perspective on why it made the decision, absent an Armstrong problem, which clearly doesn't exist here, or clear evidence, not plausible questions, not amusings, not imaginings, but clear evidence of some serious wrongdoing that indicates bad faith on the part of the government. And Rinaldi makes clear that the leave of court provision was included to protect the defendant from prosecutorial harassment. There is neither a case or controversy here any longer. The government and the defendant have agreed that the case must be dismissed. The government is not going to carry on the prosecution. It cannot be forced to by an Article III court that's outside its bounds. And the motion for writ of mandamus should be granted on all counts.
All right. Thank you, Ms. Powell. Mr. Wall, why don't you take 2 minutes?
Judge Henderson, can you hear me?
Yes.
Thank you. So just a couple of very brief points. I didn't hear respondent address what I think is the central point on the merits, which is that once they've conceded that Fokker does not allow the court to go any further with respect to the pre-plea situation, because there's no way to make the executive proceed with the prosecution. And once we know that as a Rule 48 in a constitutional matter, there's no way to force the government in that situation, they don't have any argument, either as a matter of reading the rule and interpretive principles or constitutional concerns, that would distinguish the post-plea situation. That's just not what Rule 48 is meant for, and I think Fokker's clear about that. So then really they've hung their hat on just the notion that it's too early in time. And as I tried to say earlier, I think, Judge Henderson, there are real harms that are going to come from the kinds of questions they want to ask. I mean, in the brief, they say they want to ask about the uncharged conduct. So not just why we no longer want to maintain this prosecution, but why we haven't brought separate charges against this defendant. Everybody, I thought even respondent, conceded commencement. Prosecution was off the table, but they want to ask about uncharged conduct. They want to ask about related prosecutions. They want to ask about why certain prosecutors signed particular briefs, whether they agreed with our position, whether they didn't. They want to ask questions on the reasons that the Attorney General gave, like his policy judgment that the federal interest is no longer warranted. And if the court thinks about the manner in which we are going to have to answer those questions in the district court, what we are going to have to say, whether as a factual or as a legal matter in terms of disclosing our own deliberative processes and the like, I think it's fairly clear why Fokker said courts were not supposed to go down this road. And I take the point that the train isn't at the end of the line, that it's only partially left the station, but I think that's why Fokker said the train's never supposed to leave in the first place in order to respect the division of constitutional authority between the executive and the judiciary in light of these Article 2 and Article 3 concerns like the ones Judge Rao was raising. There are real harms here. And if we know what has to happen at the end of the day, with all respect, the district court should be directed to do it now rather than have some unnecessary and very harmful further proceedings.
Mr. Wall, let me ask you something that is, I think, in your brief, but I don't think you mentioned it this morning, and that is the harm to Article 2, perhaps not harm, but the benefit of self-correction. On this record before us, if there was bad faith, it occurred in the original prosecution. And shouldn't we allow Article 2 to self-correct?
Absolutely, Judge Henderson. And I think, again, this goes to the question Judge Wilkins was asking earlier. Even if we could legally come in and not give any reasons for the motion, we did give fairly fulsome reasons, and the Attorney General had three independent rationales. And although they've challenged two of them on sort of legal bases, no one, not the court-appointed amicus and not the respondent, has said a word about the portion of the motion where the Attorney General says that looking at the circumstances surrounding the FBI's interview of General Flynn and the fact the way it went on and the way it wasn't communicated to others at the White House and all the rest, that he concluded that it was no longer in the interest of justice to proceed with the prosecution. Now, the reason they don't say a word about it is because I think no one disputes that that is the kind of judgment that is at the core of Article 2 power. It's difficult to imagine, at least outside the military context, a more core Article 2 judgment. And yes, Judge Henderson, when we put that forward in the motion, whether we were required to or not, absolutely, I think that at that point, the district court is required to grant the Rule 48 motion.
All right, thank you. Do my colleagues have any questions?
No.
No further questions.
All right. All right, counsel, your case is submitted, and Madam Clerk, if you'll adjourn court.
This honorable court is now adjourned until Wednesday, September 9th at 9:30 a.m.
That was
All
good.
participants are now in interactive talk mode. We're sorry, your conference is ending now. Please hang up.
There's 4 more minutes of this, I guess. So that's the end of that. All right, that's good news. Please hang up. Okay, well, that's a lot entertaining. Oh, man. All right, well, at least to my ear, it sounds like there's 2 votes. It sounds like a 2-1, and it sounds like there's 2 votes to nuke this thing. Obviously, that's just a best read of the way that our arguments are
Hold
going.
on, I'm sorry, I didn't hear what you just said. You said there was 2 votes for which way?
I think there's 2 votes to order the district court to dismiss.
Yeah,
I think there's 2 votes. I think there's 2 votes to issue the mandamus, and 1 vote decidedly not. So there's 1 person who seems very much no, and the other 2 people seem very much yes. The woman who was asking about, like, who is this amicus, and all of her questions are pretty much, yeah, like, this doesn't seem right, and the other judge seems like too. So, yeah. So,
but you know what though? You really can't go off the questions because.
Oh, I know that. I know that.
I fully questioning before and it went the other way. I'm like,
I fully understand that I am reading at tea leaves, and there's no way that this is going to reflect reality. But that's what I was. That was what I saw.
I think the strongest argument. I think Flynn's team has a good argument, and I think the argument is that if this is denied, will we have to now are we going to be forced to continue to prosecute a case? And even the attorney for the respondent said that they couldn't answer that question. They didn't know, and that's a dangerous answer, because if you do deny this motion and the government, then you're essentially forcing Article 2. You're forcing the executive to prosecute, and the court doesn't have that authority. So that's who I think is going to hinge on. If you believe that it's too late in the process, or if you believe that that this court is now forcing the government to prosecute. The whole, and I'll say this also too, the whole prosecutor thing and all this special prosecutor, all that was bullshit. They're not even considering that. They are considering now this fact of, is the Article 2 powers of the executive being overreached by Article 3? And another thing that you heard in this last piece too was about the sentencing. And the sentencing, what is the term they use? The court has jurisdiction over sentencing, and they're right. They didn't have jurisdiction over the prosecution, but they do have jurisdiction over sentencing. So if you're in a sentencing phase, then we're not talking about FARCA anymore, right? So where are we at? Are we in a sentencing kind of phase, or are we kind of still in the prosecutorial phase? So it seems to be a lot of more ingrained issues. But I do think the best issue for the respondent is that it's just too early. You're asking me for an advisory opinion. You're saying we should do this. You're jumping the gun. And if you're jumping the gun, then every time a defendant gets to this point, they can just come directly to you. You're not the first. This is not a court of first impression. This is a court of appeals. You know what I mean?
Yeah, I think that's a very fair point, and there are some jurisprudential reasons to let this play out, because there's some interesting law to be had where that wouldn't necessarily occur if you cut it off earlier. So there are some reasons to maintain this. I'm just trying to figure out like what the more restrained decision is, because I think the woman advocate who basically pointed out every time this has ever come up, they've always dismissed, no matter even if they ask questions or whatever, they always dismiss. So Nate, your camera disappeared. There you are. Yay, Nate's back. Yeah. It's like you either have to have Nate or Lamp, one of the two, man. One of these two things has to guide me. Yeah. I can't hear you, by the way. There you go.
You hear me now? All right.
Yeah.
Good. So at the end of so where do you think this is going to go? Do you think they're going to you think it's going to be 2-1 for Flynn?
Yeah, that's my best guess.
But you know what? I think they're going to punt. If I was on the panel and I want to do the most conservative thing possible. Number one, punt it back down, right? You don't have a decision. He's still, this is too presumptuous, right? You're asking us to rule for this judge. And since he hasn't ruled, we're going to punt it down and reserve. You can appeal afterwards, but let's hear what he has to say. That now does two things. That puts that judge under a lot of tight scrutiny now. Now he's got to really, and he knows that it's coming right back up if his answer is not the right answer.
It saves me a lot of work as the appeal court judge. It saves me a lot of work. It's like I'm gonna send this back and hope that you reach the right decision so that I don't ever have to deal with this thing. So yeah,
but don't forget
Mandamus and I, you figure it out. Please come up with the right answer.
No, because you don't want criminal defendants doing, because if they grant this mandamus, you know for a fact you're going to have criminal defendants hitting these mandamuses all the time. You did it in this case. That judge didn't rule. That's bullshit. You don't have to wait for the judge to rule. They did it in this case. Why can't you do it now? So
well, you wouldn't really have a factual predicate most of the time, because you'd be the rare situation indeed where both the prosecution and the defense have the same view of the case in order to trigger that. So the factual predicate wouldn't come up very often, I would think.
Yeah, that's true. Well, I'm thinking that there could be some other situations where, because people ask for these writs all the time in different scenarios, but I think the posture, because that's what it'll come down to, the procedural posture. The judge hasn't ruled. There's a motion. The judge hasn't ruled. He's asking for evidence so he can rule, right? Both sides say, we want you to rule this way. He's saying, well, I'm going to do an amicus to see what are some of the arguments on the other side. And now, because he hasn't ruled, they're saying, well, just because we have a fear that you may rule against us, we believe that you should be mandated to do it. So what they've essentially done, again, from my perspective, is taken the district judge's discretion away before he's actually been able to exercise it. I don't think that this is not an abuse of discretion.
Well, yeah, that is part and parcel of the issue, whether or not he would be within the discretion at all, whether or not he's acting ultra virus, basically. He's acting outside his mandate, is part of the operative issue here. But I do like your answer of punt, because, that does have a lot of conservative appeal too. Punt, you figure it out, and hopefully we don't have to do anything, and we'll just sit back and wait. That'd be great. Yeah, so I think your answer of punt also has a lot of appeal. If I were actually on the court, if I were actually on the court trying to decide this myself, God only, I have no idea what I would be doing in this situation. I have no idea.
But you wouldn't find it preferable to punt, because right now the argument would be he hasn't decided it yet.
Right.
So why not punt, see what he says, and then bring it back? What is it really going to harm anybody for them to argue the motion? They put a motion in front of a judge and he hasn't decided it yet. That's the punt.
Yeah. That answer.
Matter of fact, I'm asking you, why wouldn't it be good?
The only reason it wouldn't be good is if he's truly outside of his power and he's doing things outside of his power, even if he ultimately comes to the right conclusion, like he shouldn't have been doing those things in the first place. He shouldn't have been even asking those questions. So that would be the only counter, because again, I think the jurisdictional issues are interesting. If we don't have a case or controversy, we don't have Article 3. So even if the judge is asking the right questions, it's like, yeah, but you really weren't in a position to ask those questions because you shouldn't be hearing this. So
that's what they're talking about. And that's where I think they moved from the Article 3 case and controversy requirement, is because they were saying the judge in sentencing has jurisdiction, but it's a different type of jurisdiction. It's not the case and controversy jurisdiction. Now you have a different jurisdiction over sentencing.
Sure.
So that, I think, is a question that has to be answered too. Are we still in case and controversy land with the or are we in sentencing where the judge has authority over sentencing?
I don't know.
It seems to be where we at, and again, and now we have a motion that, think about this. The most simplest thing usually plays out. We have a judge who's got a motion in front of him. He said, let me hear arguments. And they went to the appeals court.
Yeah. But no one's appealing. No one's opposing the motion. That's what's odd about it. But then again, of course, then judges don't always have to grant motions even if both parties agree. So there's that. Just because both parties, especially if a case is ongoing, like a judge can say no, even though both parties want it this way. Like, no, that doesn't work for me for a whole host of reasons. So there's that. Yeah. But when that comes up, that's more about case management than really substantive stuff when that usually comes up. But or like both sides are just completely wrong on a legal point, I suppose, then no, even though both people would like it this way, no. And it's like, I'm not going to do that. So yeah, there is some analysis to be had here. But punt saves me the fewest headaches. So punt sounds pretty good as your Court of Appeals judge. Justice Blackleaf punt sounds pretty good. Let's do that. Yeah, I think you convinced me, Nate. I see your mic is still cutting out, Nate.
No, I muted myself on StreamYard. I didn't even. So we have a 2-0 decision to punt. We're sending it back.
Yeah, it works for me. Let's punt.
A lot of your fans aren't going to like that punt. They want death to this case.
Yeah, well, as a judge, my incentives are to try to keep my name out of the headlines as long as possible. So the trial court apparently wants this ball. So I'm like, okay, well, you can have the ball. This is on you. You play around with it, and hopefully it all goes away, and then I don't have to open my mouth. That'd be great. So yeah, that sounds fun. Let's do that. Plus, I'm not here to make my chat happy, as my chat well knows.
Yeah. Oh yeah. I've been watching Ahmaud Arbery stuff. So, but I will say this. So the arguments on both sides seem to be pretty simple. One side is saying that if you have this type of motion under these circumstances, it should just be granted because there's no case in controversy. It's over, right? Now, the other side is saying, well, that's not right because you have a defendant who's pleaded guilty, and there are a lot of collateral issues with just dismissing it. The collateral issues are, let's just go over them. Number one, he's pleaded guilty under penalty of perjury, right? And said that all of his stuff that he's doing this under penalty of perjury. So the first issue is that you got to contempt the court. If he's saying that he's not guilty now and that guilty plea was a lie, then he's just committed contempt of court. He could be held in contempt of court. That's an issue. That's a collateral issue.
I would slight challenge, because when you think about perjury, you're thinking about mistakes. You're thinking about facts and lies of fact, not lies of law. That doesn't even make sense. So like, you could be saying, yes, I did all these things, I just changed my mind on the ultimate legal conclusion. That wouldn't be perjury. So, and that's also what the government is trying to argue. Essentially, it's like, well, we're not changing any of the underlying facts. We're just changing our legal conclusion as to what those facts mean. So I don't think perjury quite works. Well, yes, I did all these things, but I just don't think the legal conclusion follows.
Well, I think the Justice Department is saying he lied, but it's not material, right? So they're saying that it doesn't meet the standard of the criminal offense. Flynn pleaded guilty and said he lied. It was material. The judge found it to be material. The prosecutor at the time found it material. So he said, yes, he committed. Oops. Sorry. Let me this. My music is so nice.
I like that.
But cool. So he's saying,
but materiality is more of a legal thing. Like, you can't really.
Yeah, it's like the judge found it to be material. Right.
Yeah, but we're talking about my own perjury. Like, if I say, yes, I knew this fact, right, and I told you a different fact, and I did it on purpose, so that's a lie. Whether or not it's material or not is a legal conclusion, not really a factual conclusion. I can say it's material, but that's a legal conclusion, not really a factual conclusion. It's an element of the statute, but that's
well, hold on, just okay. Yeah, but just to be clear, Flynn had to accept liability for every element, right? The government has to prove every element of the statute. So they asked Flynn, did you do this? Did you do this? Was it material? So they go through those questions. Flynn said, yes. Boom, guilty, right? I've done it all. guilty. So as a matter of record, as both the legal and substantive conclusion of law, Michael Flynn is guilty of those crimes.
Correct.
Period. Now we're at the point where the government's saying, well, two things. Number one, we were wrong. He wasn't guilty of those crimes. We don't feel he's guilty of these crimes after he's already pleaded guilty. And number two, now if Flynn is saying, that what I said at that point wasn't true, then I think you do have an issue. You have an issue where, is he saying that he didn't lie? Is he saying it wasn't material? Because now you do have him on record agreeing that all those things were true. So that's what I'm talking about. If you can prove that him standing up in court and telling that judge, I did this, because again, when you allocute, you have to even explain what you did. You got to explain, I did this, I talked to this guy, when I said this, it was a lie. Like you allocute, you tell the judge. So if all those facts are the same, then you're saying either the judge, the prosecutors at the time, and Flynn's defense team were all wrong.
Right.
It's an extreme remedy. This is just so weird because it's when it's happening and how it's happening. But I don't see how Flynn can get over the contempt, because he would have effectively lied. If he's saying he's not guilty now, he effectively lied when he said he was guilty.
Yeah.
Is Flynn claiming he's not guilty now?
Oh yeah, no, guilt or not guilt is also a legal conclusion. So, you can change your mind on that too. Yeah. So, there's that.
No, not if you've said it under penalty of perjury. I've been in a lot of criminal defendants. They stand over, well, they usually stand on your right side. They stand over there and they say, and the judge asks them, are you guilty of this crime, blah, blah, blah. And they have to say, I'm guilty and this is what I did. So now to say, oh no, I lied and I said I wasn't guilty. It's the definition of perjury. And they make sure they ask you in such a way where it's very clear. And that's what I think Viva had a big issue with the sentencing of Flynn, because it said, your lawyers advised you, this happened, like they went through all that, and you're sure on your mother's grave and your grandfather's soul that you are guilty.
But the government changed its mind. Yeah, I'm guilty. Yeah, I'm totally guilty. The government says, no, you're not. I'm like, okay, well, they don't think I'm guilty. So, I mean, okay, I guess, I thought I was, but now, I stabbed the guy and I meant it, and I laughed about it pretty hard, but they don't think I did anything wrong. So what can I do about it?
But also, let's do the fact of the matter. The fact of the matter is this case should be dismissed. This case, and I'm going to be very clear with everyone. This case should be dismissed. Flynn should be allowed to go home. This is all BS. Do you agree with that?
I think that they definitely set him up for no particular reason. And this whole thing is a fabrication from square one. And the FBI really shouldn't do that. So I have some objections to that. Yes. So I don't really like we just want to have a conversation with you and we're setting you up for a perjury trap. That's not really a good thing. We should stop. Let's stop doing that. That's good.
Yeah, I see. I'm agreeing with you 100%. I want everybody to understand. I think Flynn should be set free and it should be over for Flynn. That's not the issue. The legal arguments that I'm making against Flynn is because I think its situation is so unique that it does lead to more questions. Was it when he lied to the FBI? Then he lied. Then did he lie about lying to the FBI? Did he lie about not? Did he lie about being guilty of lying to the FBI? I certainly
have
here.
Yeah, I have no objection to you saying, well, this is what I think should happen, and legally here are the right results, because I do that sometimes too. Like I've said on my channel, one of the marks of a good judge is you reach conclusions you don't want to reach. And so, for example, in the Amaya Cohen story with the girl who said I have COVID, and the sheriff shows up at her house and takes it down. Right? I've been covering that case, and I'm like, yeah, Maya's going to lose, and I don't want her to lose. I think she should win. So, what I think should happen and what I think the legally correct result are not necessarily continuous. So, the law, and it's really interesting. It comes, at least one of the major legal issues is the severance between the liability phase and the sentencing phase. Whether or not those are, how discrete those two are in terms of whether or not we've moved past a veil or Rubicon or something, and so some of the rules get changed, is a very interesting legal question that doesn't have a immediately obvious answer.
Well, I think the jurisdiction of the court changes definitely for 100%, because the jurisdiction of the court when it turns to liability is one of a referee, right? Sometimes they'll be the finder of fact, but usually you have the jury of the finder of fact. They're the referee. They're the judge of the law. They'll say, this is what you can present, what you can't present. And then after you get that liability portion done, then the court turns into not being a referee, but now being an arbiter of justice. In other words, they're now saying how much time you get. This has been so bad that this is how much time. And there's the what they call the theories of punishment that the sentencing guidelines says the judge has to evaluate in sentencing you. So the judge now becomes the arbiter of how bad was this crime, because they can't say you did the crime, but they can say how bad the crime was that you've been found guilty of doing. And that jurisdiction is different. And as I was even saying it inside this, the advocates were saying that no one would deny that the judge has Article 3 powers in sentencing. Right now, they're saying, well, this is not sentencing, so we are in this gray area. And it's such a fine point, because if this was before Michael Flynn pled guilty, this judge would be smoked. Like, Sullivan would be gone. This is it. Mandamus should be granted, right? Because you can't force you can't force the executive to prosecute. If they say we're done, we're not doing it anymore, that's it. Judge Sullivan has nothing. But it's after the guilty plea. If this didn't happen at this particular point, you wouldn't have these arguments. But since it's happening here in this very gray area, right before sentencing, right after the plea, where is the line? And that's what we're looking for now. Where's the line?
No, absolutely. On an unrelated note, as my chat knows, I am experimenting with a Discord. So Nate, would you like to join my Discord? And then I'm going to also get Viva to join my Discord, and we can have a little legal fiefdom. So so you can send your fans over here, and we'll have Viva over there, and anyone else who wants to join in the YouTube law community. We'll try to create some relative spaces. Yes, and I'll give you. We'll create a new category for law crew, and we'll make you look cool.
I wanted to ask you something now. Sure. I wanted to ask you something. I got yelled at the other day for this, for my opinion on this, but I wanted to ask you about it.
I get yelled at for trying to define escape. So sure, what do you got?
I believe second-degree murder for Floyd is too much.
You mean in terms of the sentencing, or you mean in terms of the legal proof, or what?
I'm talking about in terms of the charging documents. I think the second-degree murder for Floyd is too much, and I think third-degree murder is fine. I think you have that, but I think the second-degree murder charge in Minnesota against Floyd, I think that's an overcharge. I think it's an overcharge. I think it's an overcharge to please the mob. I don't think it's a charge that can realistically be proven.
I still have some people in my chat trying to squeeze this into first-degree murder, which I'm like, no, that's not going to work.
First degree, no.
Yeah, no. One of the issues, because I was looking into this a little bit, and I ran into a article written by, I think it was Heritage Foundation, and they cited a case from Minnesota on third-degree murder that seemed to stand for the proposition that you couldn't use third-degree murder here because third-degree murder has to be undifferentiated. And so it's a general state of recklessness rather than in particular. So the very fact it was to a particular person might preclude it from being third-degree murder, which I said, that doesn't make any sense, because normally third-degree murder is a lesser included, and if you can prove second, you've proved third. So the idea that if you can prove second, you can't prove third because it was targeted doesn't make any sense. But there was one case that seemed to stand for that proposition, so I was like, okay, that's kind of weird. I'm still not sure how you're using an outlier. I'm still not sure how you're using the felony assault as the underlying felony for the felony murder. I'm not sure how that's a thing. That seems like double jeopardy. I'm not sure how that works.
Yeah. Well, it's the underlying crime. It's the underlying crime. It's like charging someone with burglary and trespass, but not understanding that all burglaries are trespass. You have
all burglary or trespass. Yeah, you can't do both. It's like you're using the trespass as the predicate for the burglary, but it can't because it's like it's already baked in. It's like so
it's one of the it's one of the core elements for the overriding offense. So
Right.
in other words, so this is just for the crowd. So for instance, if you like with burglary, all burglaries are trespasses. So in other words, to commit a burglary, you have to trespass. So since the elements of trespass are absolved in burglary, this is the merger doctrine doesn't allow you to then charge for just trespass and burglary. You have to charge for the higher included offense only.
Yeah.
Or you can charge both. But the jury can't find.
You can't convict them both.
Could do both. Yeah.
So here you're trying to use the underlying felony assault as the predicate felony for felony murder, but that very assault was what created the death, and so essentially you're using a murder as a predicate felony for the murder, and you can't do that. So I'm not sure how this works. That makes no sense.
Well, I can see, you know what, because I know sometimes they get it in false imprisonment, where you're arresting the person, like for instance in Marbury, you're arresting the person illegally. Then you have false imprisonment, and then committing the false imprisonment, you get the felony murder. That's how they got the guys for Marbury. Yeah, they're getting it for felony murder because of the false imprisonment. So you'd have to have some other underlying felony other than just the assault. And I don't understand what they could produce.
Yeah, you can't use false imprisonment for the police because it was at least in the initial instance, it was a legal imprisonment.
It was a legitimate arrest.
They had probable cause.
They had probable cause.
Yeah, they had probable cause that went way outside the realms. But yeah, so you can't use false imprisonment. You can't use kidnapping. You can't use So how's this working logically? The AG was on like the Today Show, and he said, "Oh, I'm going to use this." I'm like, ugh. I'm hoping the AG is a smarter lawyer than me, because I'm not sure how this is working. So
and let's not forget, it's all Minnesota law. So I'm not sure what what the Minnesota statute really is, but I just think it's just fascinating that that they don't have a murder doctrine. I don't think they do. The murder doctrine doesn't apply in that state. And I'm wondering if it doesn't, then how do you get past double jeopardy? Because you're literally going to be finding somebody guilty for the same offense twice. That's
not going to fly. Yeah, that's not going to fly.
It just seems that way. I don't know how you get over that, because you're going to, because the murder is an assault inherently, and then you're going to have to charge them with assault again. I don't know. It just seems weird. But
unless you can go to actual intent, and what makes it a little bit more interesting, because I was using this, I think, before you popped on the stream, I was pointing out that in the FBI cases with the 1001 charge, it's very typical that they will advise you about that. They'll give you a warning. They'll give you this 1001 warning. It's like, by the way, just to remind you, it's illegal to lie to the FBI. And one of the reasons they do that is to help establish intent, right? So they're going to actively remind you that this is a thing, then put it in your head. So now when you do it, it's like, we had intent because we actively warned you. And so now we can get to intent easier. So by parallel, when everyone on the face of the earth is screaming at this cop, get off him for God knows how long, for 6 minutes before he died or whatever, then that active knowledge state, now it becomes a little bit easier, not easy, but easier to try to get to actual intent, because we're putting this knowledge in your head, and now you're acting with that specific knowledge that this is going to be a problem. So maybe we can get to intent for second degree. Not saying it's easy, but it's possible.
But
$5 from Lizard.
I'm not ruling out second. I'm actually not ruling out second degree, because I'm doing a little more research. Yeah. They've actually found out that they worked together at a nightclub, and they knew each other. So these weren't even strangers. These were people who knew each other.
If you can show that they had some animus between them, that would be super helpful. Yes.
Yeah, but I just don't know. Some people were saying that they had some animus, but right now, I just don't see second degree murder. But Keith Ellis, he was the congressman. I think he's going to make his bed. So we'll see.
I don't really see any liability for the officers who were brand new on the job, because was it 2 of the officers who were brand new on the job, or only one of them?
Yeah, like one guy was 4 months, one guy was like 4 days.
4 days. Yeah, 4 days, and the guy was his trainer. How do you get to any criminal liability for this guy at all? How do you get to a mens rea for this guy?
And that's a scary part about this case. And you know, as two things, as somebody who is Black in America, I do want to see justice for George Floyd, and I believe that the cop who did the knee on the neck, he should be prosecuted. He should get third-degree murder. He should spend 25 years in prison. I don't think anybody's going to disagree with that, right?
Nope.
But I do think
that guy's a cool MFer.
No, for sure. He should be, you know, he should.
If it wasn't that, maybe it was the last 18 excessive forces, you know, that you should have gotten a memo on, you know, you jackass.
No. That again. Then besides that, but the legal issue is that can you prove, you know, if he was convicted on second-degree murder, that's just going to make it easier for other people to get convicted of second-degree murder. And there's legal standards that I think we want to uphold. And then for the other cops, think about this. You get to a new job. Somebody says, this is somebody who's been in the job 20 years, 19 years, right? Somebody who's getting his pension. This is the person who's going to be training you. So follow their instructions, follow the demands, and then when you get to your feel of things, then you can start making your decisions. So you go out there, and this guy is telling you what to do, and he's doing this, and you're thinking it's okay. And now, and now,
he must know what he's doing. He's my trainer. Well, I'm only been on that job 4 days. He must know what he's doing. You know, the idea that he formed the requisite mental intent. I'm like, this at least one of these guys has got to have their cases dismissed. He has no liability. How are we getting to liability for this guy? You know, it just doesn't make sense.
Under the accomplice. Well, they're doing it under the.
Oh, I understand the legal theory, but you can't even get there because you can't get to the mental state for accomplice. You know, that we even knowingly assisted someone by aiding and abetting them in commission of a felony. You know, you can't just because I loan you my car doesn't make me liable for the bank robbery or whatever you're doing with my car. I have to have some knowledge that you're doing something illegal. You know, so you know, you can't even get to knowledge. I'm not even sure you can get to negligence. I mean, you can't even get to the barest mens rea with a guy who's brand new on the job. You know, 4 days in, you can't even get to negligence. Like, oh, it was, you know, you can't even get there. So I'm not sure how you get to the aiding and abetting.
You know what? What about so the guy who had 4 years on the job? He's done aiding and abetting.
He's a lot more promising. Yes, the 4-year guy is a lot more promising. Yes.
Yeah, and the 4-day guy wasn't he the guy holding him down too?
I'm sure. I'm sure he did. I'm sure he was helping hold him down. But even still, it's like, how do you get to the mental state of, oh, I was knowingly aiding and abetting an ongoing criminal activity when this is my superior who I've been told is trained and has obvious experience and must know what he's doing. So yes, I was assisting, but I didn't know I was assisting a crime. You know, I didn't have the right mental state. It would be like similar to like, yes, I held open the door for the bank robbers. I just didn't know they were bank robbers. So it's like, you know.
No.
I was the Uber who picked them up and somehow didn't notice that they were that they were criminals.
Hold on. Well, there's a little bit more facts. Like, you know, if I came to the bank with the bank robbers in the same car and, you know, held open the door and they went in and started robbing the bank, I think you could make a reasonable inference that, you know, they were, you know, that based on the circumstances now, you know, you were there, you were assisting. But I think in this situation, I think you had something where you had people thinking that they were making a lawful arrest, and you have somebody who's on the job for 4 days. I agree with you 100%. It's going to be very hard. It would be hard for me to convict a 4-day cop. You were just on the job for 4 days. That was your training officer. Yeah, it's going to be hard for me to convict him for aiding and abetting. I just don't see it. But the other two cops, the 4-month guy, I'm a little bit less leery about too, but the other one for 4 years, he should have known.
That's a little bit more promising, right? That's a little bit more promising, yeah. So the guy with the knee on the neck is guilty of something, man. I mean, you know, it has been suggested, and I think it's probably true, that a lot of it was just ego, that it was almost specifically because members of the public were telling him to stop. It's like, well, I'm not going to stop because you told me to stop. I'm going to show you who's in control. So it's like almost like just a straight ego thing, which also kind of underlines the intent to murder. It's just like, I'm going to exert my power. Now, again, the thing that's kind of going the other way is him being actively warned and all that stuff by everyone, and like his training and experience and blah, 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 blah. So yeah, I think a jury could find second-degree murder. I just don't think it's a slam dunk by any stretch. So
no. The slam dunk is third-degree murder. The slam dunk is manslaughter. I think you got him for that. Yeah, it's like, you know, he's spending. he's going to get 25 years in jail, no doubt about it, right? But you saw.
Oh, if I'm the judge, I'm maxing this guy out. Fuck this guy.
Yeah. Because he's doing it under color of title. He has a badge, 19 years experience,
and the 18 prior incidents. It's like all that is coming in to kill you. I can't use it for liability, but I'm damn sure using it for your sentencing. All that crap. When I'm analyzing your character, oh, you're not that great a guy. Yeah. So how about all the time?
Yeah.
How does all the time work for you? Is that a good number? All that? Yeah. So So I don't know. The liability issues are pretty interesting, but yeah, I really hope something gets done. I was looking also at some of the federal proposals. The one that I saw, at least the rough draft, was they wanted to make it a crime for federal murder or federal manslaughter if you under a color of title if you were getting funding from whatever as part of the federal government. I'm not sure you can use spending power like that to create criminal liability. I've never thought about it. So I'm not sure the hook works. There are other ideas that might be more promising. Like Article 4, Section 4, guaranteeing a Republican form of government, I think would be a more promising constitutional hook rather than spending power. But I have no problem with that in terms of that. I think we should even go further than that. We definitely need to do something about qualified immunity, either Congress or the Supreme Court. You want to be fine.
Hey, on civil law.
Yes.
You have my phone number and everything on the screen.
Crap! I'm sorry.
You totally doxed me out, brother. No.
I could hide the stream or something because I wasn't. I keep forgetting what windows are up.
Man.
They want me to hide. I'll take down the stream if you want. Because I don't want to dox you. Would you like me to take down the stream?
Well, I would not like. Well, you got everybody's number out there too. You got Viva's up there. You got a whole bunch.
All right, I'll just.
I think you need to.
I'll take down the stream. All right, so I'm gonna end the stream and I'll think it's sorry. I'm sorry, Nate, about that. That's my bad. So I'll make it private. I'm sorry. So I hope you enjoyed it. But yeah, until I can edit it in post, I'll edit it in post. But I have to go back and actually edit. It's gonna take forever. So thanks everyone for being here. Until later, my friends. Peace. Bye.
Peace.